May I please? But with regard to item 64, my lord, so the part heard matter, my lord. Lordship already heard at length, my lord, regarding the NDPS case. In this case, my lord, only question arises during the last hearing, my lord, whether the sentence can be suspended after the conviction or not. That was the only Lordship has made the query, and Lordship asked me to submit any judgment with that regard. Only that part is there. Apart from my Lordship was,
Now, what do you want?
well, I want just to place the judgment, my lord. Otherwise, Lordship has, my submission was there is a non-compliance, total non-compliance of the 42, my that's Lordship knows. And the total non-compliance of the 42 of the NDPS Act reshapes the entire trial. It is not permissible as per the Supreme Court full judge's benchmark. So when there is a total non-compliance, then the rigor of the 32, that is not the bar, which has been bar created by the otherwise by the NDPS Act 32A, which has been declared as an unconstitutional. And the Supreme Court also held that the suspension of sentence is permissible when there is a total non-compliance or there is a chance of acquittal of the accused. So, Lordship, on this, my only prayer is by virtue of these two judgments, Lordship can dispose of the matter.
Okay.
That's all.
Then this interlocutor application would be fixed for order, for delivery of order.
My
Say in 64, heard Mr. A. M. Bora, senior counsel, assisted by Mr.
D. Chaudhary.
B. Chaudhary. Yeah, B. Chaudhary appearing for the applicant slash appellant. Also heard Mr. R.J. Burwa, additional public prosecutor. No, Mr. Burwa, you go through the judgment. If you have to say anything, at two you may reply. We will fix it for delivery of order. At 2 I will pass out.
In I am absent till my opinion. I'll try to be there. So only that part on my left. The Lordship has
No,
already,
let him go.
already Lordship has gone through the entire. I have annexed entire by the evidence in this case. There's absolutely total non-compliance. There is no whisper about the mandatory provision requirement that has been followed. That he reduced the writing, informing in the later stage. There's no nothing that all witnesses not a whisper. So there is total non-compliance. So that's the only thing.
You
only.
go through both the judgment.
And the second judgment is I have given the 42 judgment, two judgments regarding 42, and whether the suspension of sentence is permissible during the appellate stage. That's the only judgment.
Thank you. Item number 60, Lord, 60. Can it be taken up as two, Lord? The arrest warrant has been issued against the petitioner. It's a supplementary list. 60.
No, we'll call it serially. Other matters are also.
Sir, it may not reach also, Lord. That is why I'm submitting.
Many
Where
matters.
arrest warrant PNA issued against the present petitioner. At two, Lord.
It would. Let us see whether how much we can go.
My lord, in item number 36, we have filed an additional affidavit day before yesterday, my lord. Let me kindly call for.
In 36.
May it please the Lordship, I'd like to mention item number 42. This matter may be taken up in the next week, Lordship.
42. What is your prayer?
To be taken up in the next week, Lordship.
Next week. Heard Miss T. Som, learned counsel for the petitioner. Why are you praying for adjournment? Case diary has arrived.
Is there yes, sir? Is there yes, sir? Is there yes, sir? Series.
Heard Miss T. Som, who prays for an adjournment. Also heard Miss S. H. Bora, learned additional public prosecutor who submits that the case diary has not arrived and prays for some more time for producing the same. Prayer is allowed. You are on interim.
No, Lordship.
The prayer is allowed. Let the case be fixed again on
1/12, Lordship.
1st of December. or-
Along with the case diary. Lord.
Yes, for case diary.
Lordship.
Of Lordship.
May I please? My lord, in item number 4 of this list, I have filed on additional affidavit, so that may come on record. Flash.
May it please your lordship, I beg to mention item number 39. I have been informed that CD is not available.
39 CD is not available.
Heard Mr.
Interim
Yes.
process.
Kakoti, learned counsel for the petitioner, also heard Ms. S.H. Learned additional public prosecutor who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed
On
again
18/12, Lordship.
But-
Petitioner is on interim.
on 20th of December for case diary. The interim order shall continue till next day.
Lordship.
May it please your lordship. Lordship, prayer for listing and criminal revision petition to 31st of 23, lordship. Lordship, the matter relates to ex parte order passed by learned trial court under section 125 CRPC. And service already has completed, lordship. The matter may come in the order follow.
No, but for that you have to pray before registry. Yes.
May I please, your lordship? I will mention my lord for listing criminal appeal, my lord. Who was convicted 2 years in POCSO Act, my lord. He's
Right.
behind the mark since last 2 years, my lord.
It's a new case.
No, my lord.
You pray before registry. Make a prayer before registry.
May I please your lordship. Because in connection with item number 14, I have filed an additional affidavit. They may be allowed to brought into record, your lordship.
14 edition. Yes. Okay.
May I please, your lordship? My lord, item number 18. So far as my instructions are submitted, I will approach before the learned court below.
Heard Mr. A. Paramani
18.
who submits that charge sheet has been laid in this case and you want to withdraw the and he prays for allowing the petitioner to withdraw the instant bail application as the petitioner wants to approach before learned trial court for praying for necessary relief. The prayer is allowed. This case is dismissed on withdrawal.
May I please your lordship? Lordship, I beg to mention item number 49 of the daily list, lordship. It may kindly attend for the day, lordship.
Why?
Lordship, my senior has some personal
Heard
difficulty.
Mr.
Mr. B. Talukdar.
B. Talukdar, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the learned leading counsel. Case diary is there.
CD is not available, Lordship. Petitioner is on interim.
On the other hand, Ms. S.H. Bora, learned additional public prosecutor, submits that the case diary which was called for has not arrived and prays for another date for producing the same. The prayer is allowed. Let this case be listed again on
Let it be on 18th of 12, 18th.
18 December. The interim order shall continue till next date.
Highly blessed, lordship.
Not 5, 8, 6, lordship. 6. And this counsel of the case is out of discussion, lordship. Kindly until the matter.
Heard Mr.
J.M. Sulaiman.
J.M. Sulaiman, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel is out of station.
Lordship.
Considering the ground, the prayer is allowed. Let this matter be listed
After
again.
2 more.
No, not day after. When?
6th of
6th of December.
May I please, your lordship? I have mentioned for listing in bail hearing. For bail hearing, let's say left of the CD also available for witnesses.
Can copy.
May I please your lordship? Lordship, I beg to mention anticipatory bail matters for listing tomorrow. Actually, the bail hearing for Rico Akusi is also tomorrow.
It is also fixed, listed tomorrow
In the daily court list of the court too,
in this court.
in this court, madam.
Okay.
Much obliged.
May I please your lordship?
Lordship, I beg to mention item number 38 of today's list. In this matter, Lordship, scan copy, lower court, scan copy was called for along with the case diary, Lordship. It has not been.
30. 30.
Yes, yes. 38. 38.
Heard Mr.
You
U.
Chaudhary.
Chaudhary, learned counsel for the petitioner, who submits that. Also heard Ms. S.H. Bora, learned additional public prosecutor, who submits that a scanned copy of the case record, LCR, which was called for in connection with this case, has not yet arrived.
LCR along with case diary.
LCR along with
Along
the
with case
scanned
diary.
copy of the along with the scanned copy of the case diary has not arrived. Issue reminder for this. Let this case be listed again on 13 December. You are on interim.
No, Lordship. Earlier date may be given.
An
Lordship.
earlier date,
8th of December.
8th of December.
Tell me in this month, Lordship, any day, last day of this month, Lordship. Time will be given.
Before 8, you are. Is it possible?
In the month of November.
In the month, December 1st week.
December.
4/12.
4/12. Obliged. Can we 5 5th of December, Lordship. Obliged, Lordship.
May it please the Lordship. May it please the Lordship. Lordship, I am praying for a permission for listing of an IA, my lord, for suspension of sentence. It was directed to be listed this week, my lord. The 10 years conviction, my lord.
It will be listed. Week has started only.
So, my lord, I am praying for on 22nd, my lord. 22nd of this week, my lord.
Okay.
TPL that.
May it pleases your lordship. Lordship, I beg to mention an item for listing. It is a bail application. May this matter be listed tomorrow.
When have you filed?
It is filed on 16/11/2023, your lordship.
Okay.
Deeply obliged, Lord.
Lordship, I like to mention item number 62, Lord, of supplementary list, Lordship.
62, what is the prayer?
Lordship, this matter may take at 2, Lordship, because my senior has some difficulties, Lordship. He will not available in the second half.
But there are other methods. It is subject to if we finish the bail method. 62 is a
Admission, Lordship.
Criminal appeal.
Appeal, Lordship. Admission, Lordship.
Yes, it is after completion of bail method we will take.
Obliged.
Lordship, I beg to mention item number 24. Lordship, my senior is not present today.
Mr.
Lordship, the interim.
What is your name?
W. Ram.
Mr. W.
On
Rahman,
behalf of Keshan.
who prays for an adjournment on the ground of difficulty of his senior, who is the conducting counsel in this case. Case diary was called for.
24, CD is not available.
Also, Ms. S.H. Bora, who submits that the case diary has not arrived. The prayer for adjournment is therefore allowed. Let this case be listed again on
2012, Lordship. Petitioner is an
2012
interim.
for case diary. The interim order shall continue.
Hello.
Daily list motion दिया है. May it please the Lordship. For 439 bail application, this has been registered under section 363, 365, and 373 IPC.
376.
Yes. CD,
How long you are detained behind the bar?
date of forwarding is 27/10.
27/10, my lord. So if the 409 will not affect, my lord, then
As on today,
what will
24
kindly
days.
see the FIR, my lord, at page 12, my lord.
CD
At
will
page
review
12, my
Lordship.
lord.
Why the bail was rejected by the trial court?
Rejection order at page
Rejection at
18.
page 18, my lord.
After perusal of the case diary.
Yes,
lord.
Lordship.
So case diary would be.
Yes.
Heard
Short date, my lord.
heard Mr.
Havari.
A. Havari, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. Considering the allegations leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of instant bail application, hence call for the case diary. Fixing,
It's 11-12, Lordship. It's coming from Dibrugarh. Lordship. Dibrugarh.
give a
police.
short date,
Lordship, then 8.
8/12.
May I please, Your Lordship, call for the CD Lordship.
Heard Mr.
N. Ahmed.
N. Ahmed, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor. Call for the case diary. Fixing,
On 9-12, Lordship.
9/12 for case diary.
Lordship, I'm sorry, 9 is a holiday. Lordship, can it be on 11?
11/12 for case diary.
Diploma.
Item number 4.
May I please, Lordship, I made mention, my lord, this morning to bring on record the frauding report, my lord, that is yet to come
Okay, we'll take it up after.
after some time. my lord.
That forward.
Or
More or less.
Thank you.
It is
আমি
already
আমি
come
কিছু-
in my.
আমি
possession,
কিছু
yes.
copy, not on the top.
Maybe it is. They don't know that.
Or my lord, London TP submitted that our copy that we have sub that is available.
If that is available, Lordship. That forward.
Okay, what is the, since when you are detained?
My lord, I am in detained on with effect from 6th of November,
6-11, Lordship.
6/11, my lord, and I am not named, my lord. Whatever, nobody is named here, but so many persons were arrested, my lord, and they were released also, my lord, by this honorable High Court as well as CGM, my lord. This honorable High Court, my lord, without CD even, my lord, on considering detention period. My lord, kindly see page 10, my lord, FIR. Only on the allegation of theft of mobile phones, my lord. Some unknown persons, my lord. I am not named in this affair, my lord, and I am not involved also, my lord. Kindly see page, my lord, 13 to 17, High Court's order. my lord.
Which page?
Page, my lord, starts from page 13. And then 14, my lord, relevant. It is directed that the applicant be released, my lord, page 14, my lord, 140.
No, they are released after period.
It is of the case study.
Here, my lord.
Lordship, only give us a short date. It's from Horulumuk.
We are fixing a short date.
Yes, Horulumuk PS.
Heard Mr.
AFNU, my lord.
AFNU Mullah, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. Let the case diary be called for.
Lordship,
Fix.
on 4-12.
Give a short
Thursday or Friday.
Then Lordship, on 30th. 30-11.
30/11.
Also too long, my lord. Nothing is there, my lord.
Let it be on 30th.
Friday, my lord.
Try on Friday.
Lordship,
Try on Friday.
okay. Lordship, can it be on 28 then?
28.
28.
Public.
Supplementary list item. Oh, the CBI matter, but we have the petition.
My lord, same matter you also heard. Two matters are on 15 of this month. This is, in this case, my lord, he is the police informant. My lord, he also reflected in the charges submitted by investigators of the CBI. He is a police informer. As per the instruction of the police, he associated the Junmuni Rava, accused number one. Accordingly, the present accused being informed.
These other two cases are not
Listed today.
listed today.
Yes, sir.
It ought to have been listed.
Yes, sir.
So we'll
Fix it. Another date, Lord.
day after tomorrow.
So,
What is your,
His ground is the length of detention.
No, I'm coming to that, my lord. So far, inference is very, my lord. It is reflected in the charges submitted by investigators of CBI that I am the informer of the police.
you are the informer.
I saw the houses of the accused persons. Accordingly, raid was conducted.
Since when you are detained?
My lord, on 29/5/2000, 23,
Yes, 23, as of now, 176 days.
176
Six days, my
days.
lord, yes.
Okay. So your ground is you were informer
Yeah,
of
it is
police.
reflected in the 16.6. Yeah, 16,
Okay.
16.6 and 16.12, it is says, my lord, that one Riyazul Islam, one of the informant, he paid rupees 20,000 from the bank account of Tahir Ali to me. And so far as the my bank account is concerned, task is late. You also kindly see page 40, order passed by Lanet CGM. Page 40. Taken cognizance of 24/8/2023.
Yes.
It is said, my lord, the charge sheet case record is received for disposal. Peruse the case record, including the EJR FIR from charge sheet, along with the list of the witnesses as per annexure list. There are 75 witnesses cited in the charge sheet. List of the document as per annexure B, list of the articles as per annexure C, and CBI case record showing pertaining to not looking for PS case numbers. IO in this case submitted charge sheet against the accused person. So in the academic cognizance has been taken under section 120B, 388, 395 of the IPC. So far as the my lord, and next page 42, it is ordered by the CGM. My lord, along with the other accused, I also moved a bail application, but the London CGM rejected the same, saying that considering the seriousness of the offense, has also said, my lord, that my lord, since the section 395 of the IPC is tribal exclusively cited by the Court of Session. That's why bail is rejected on 24/8/2023. And so page my lord 46. They also order passed by learned. Season page 12/9/2023. In this case, my lord, investigators of CBI submitted a written prayer permitting him
Yes.
yes, my lord, with a prayer to permit him to some more time to carry out investigation to unearth the larger conspiracy. So he was given 3/10/2000 as a large opportunity. But Lanet CGM given him large chance to 3/10/2023 without any delay, directed the IO to file final form of this case. He was to find a page. Yes, page my lord 46. I am of the considered opinion that further time is required to be given to the IO till 3/10/2023 to submit final form in the case. But it is noted here that last opportunity is being given to the IO and he is directed to submit the final form invariably without any further delay on or before the next date fixed on 3/10/2023.
Okay. Now what is your submission?
My submission, so far as in this case, charge sheet has already been laid. Elosified from all further under CGM, my lord, entire document, and there are 75 witnesses citing the charge sheet. Trial is yet to be conducted, my lord, and there is no any likelihood of completion of trial in the near future, my lord.
Okay.
And whatever may be the seriousness of the offense, my lord, every accused has a right to defend himself properly and fairly, my lord. Conducting the trial, detaining him in jail, my lord, would my entire amount to my lord, deprive him to the defend himself properly and fairly, my lord. Therefore, my lord, and then there is Supreme Court judgment, my lord, only on the ground of delay. Since the trial will, conclusion of the trial will take a long time on the ground, my lord, Honorable Apex Court, without making any comment on the merit of the case, granted bail, my lord.
Mr. Halloy,
Lordship.
what is the
Lordship, the ground taken by this accused person is that length of detention and the Lordship trial, when the trial will commence. Yes, because number of witnesses are very
75.
75 witnesses. But Lordship may kindly have to look into the FIR, Lordship. The seriousness of the allegation. He is one of the recipients. He is one of the accomplices who, Lordship, accompanied the entire team to extort money from the informant and his son, Lordship.
My
Lordship, charge sheet has been submitted against this accused person along with all the other accused person, Lordship. Further investigation is pending, and therefore, if he be released on bail, Lordship, there is every possibility of tampering and tampering with the witnesses.
My lord, the entire case handling by the CBI.
Let me submit. This will be moved. These are the ground, Lordship. Severity of punishment, Lordship. And
okay,
Lordship.
we'll pass orders along with other two matters.
Well, so far as the hampering and tampering of it is concerned, my lord, it is a case handling by the CBI. Can I dare to, my lord, to make any hampering or tampering prosecution witnesses, my lord? Can I make any attempt to hamper tampering? It is handling by the CBI, a serious case, my lord. Still, my lord, there is a clue, my lord, who killed this, my lord, young lady police officer.
That matter is not the subject matter of the.
No, yes, my lord. This is what is the yellow, my lord?
The death of Junmani Rabha is not the subject
No,
matter.
no. Yellow say fine.
Munir Rabha is accused in this case.
Okay, that is a different case.
Case.
You see, find para 16(6) of the charge sheet, my lord. I am informed of the case. I shown the 6 houses.
Okay, you have already submitted that.
My lord, yes.
Heard Mr. F.K.R. Ahmed, learned counsel for the petitioner also. Case diary is
Case is available.
also heard Mr. M. Haloy, learned special public prosecutor CBI. Let this matter be listed for delivery of order day after tomorrow on 22nd November. Day after tomorrow will pass out.
Right.
Hello.
Right.
For motion item number 5.
Okay. Matter related to the Juvenile Justice and Protection Act 2015. We have challenged the order dated 11/9/2020, case number 14.
Page number?
Page 14. This is the rejection matter of custody of the CCL legal guardian. Page number 14 and exact to 11. Sorry, page number 16. 9/10/2020. Page number 16. Relevant part in page number 17, detection order.
Case diary would be required.
Yes, sir.
In a way, yes, because they have rejected the guard for handing over to the guardian because of the severity of the crime.
So whether
Uh,
we have to go through the case diary.
Lordship, yes, we'll have to see how far. Otherwise, under Juvenile Justice Act, perhaps if he is not found to be in conflict with law, then he'll be handed over to the parents. Otherwise, he'll be there in the observation home.
Submission, Lordship. I have annexed the.
That I have not supplied her the copy of the deed. But she has said that she has put her signature. The allegation is of forgery and cheating, my lord. And my lord, your lordship sees on 23th, the accused may obtain the NOC in my name without my knowledge, nor I was informed, my lord. She has submitted an application. The NOC has to be issued by the authorities, my lord. And my lord will see that she has lodged a complaint before the circle officer, Miss Case 4 of 2000. Accordingly, in terms of someone issued by the authority concerned, I was present so and so. However, the accused remained absent. On 21/8/2020 in the office circle, I had been supplied the NOC. And thereby the circle has shown the inability to take the decision. My lord, it was not within the jurisdiction of the circle officer to cancel this NOC, my lord, because it's been issued by the deputy commissioner under 21A. Thereby asked me to lodge an FIR. My lord will see this FIR has been lodged at the instance of the circle officer who has advised.
Where it?
My lord, bottom, my lord. On 21/8/2020 in the office of the circle officer, page 39, as your lordship got, my lord. I had been supplied the NOC and thereby the circle officer shown the inability to take the decision in the complaint and thereby asked me to lodge an FIR as well as to approach the office of the deputy commissioner for needful action. As such, the above situation, there is no delay in lodging the FIR, knowing in fact cheating of the accused. I have also known land mafia, so and so conspiracy, land. But I have entered into a valid agreement that gives me a right. She has given an affidavit, my lord. But if it is not abuse of process of law, then what it is, my lord?
In fact, as far as 468 and 420, I think the ingredients are there in the FIR. Because initially, although she had entered into that agreement, but then the deeds and all were not, the copies were not given to her. Thereafter, she, NOC, of course, it's little difficult to believe. NOC was issued in my name and without my knowledge. If her signature is there, then that has to be looked into. But as far as
Allegation is of forgery of signature.
forgery of signature.
With due
So
respect,
in the NOC
no,
or
NOC
other,
signature is not required. NOC is issued by the deputy commissioner on the basis of the application submitted.
NOC, yes, this NOC, I don't know, this NOC in my name without my knowledge.
No, suppose investigation. Let us issue notice.
With due respect to the submission made by your learned friend, Lord. As regard 420, Lord, the ingredients should be, Lord, from
No,
the initial
and
stage.
let us go through the record.
My lord, if I am able to, Lord, just your lordship may permit me 2 minutes to make my point.
You only satisfy, you are praying for interim relief.
Yes, my lord.
How you are, you would suffer if,
Lord, the police is after me, my lord.
for that you have other reliefs.
My lord, if I am able to satisfy your lordship, Lord, the entire process is, Lord, mala fide, and Lord, on the basis of the materials that have been submitted
No,
before you,
but
Lord.
for seeking relief against apprehension of being harassed.
My lord, not on, my lord, I am on that this FIR is not at all, my lord, which says that an offense has been made on the basis of the facts that I have alleged. Reading of the FIR would go to show none of these offenses are attracted to me. But for cheating, there has to be an initial, blood element that from the very beginning I intended to cheat them. But where is that? Blood, I want to pay, I have taken the stamp, I want to execute. Rather, blood, this is a cheating on the part of the informant, where she says that this land belongs to me. There are 3 pattadas. NOC has been issued in the name of 3 pattadas, my lord. Payment has been made in name of 3 pattadas. All 3 have not come, my lord. And she says that I have signed the document. If she has signed the documents, how it becomes, my lord, forgery? The next offense, my lord.
No, where she has said she has signed the document.
My lord will see. Page 39, first paragraph after. Accordingly, as per discussion, the accused Pinku Medi paid an amount of rupees 2 lakhs at advance on 25/2022, and he assured to pay the rest of the amount in the last part of September. The accused Pinku Medi took my signature in the stamp paper on so and so in the name of deed of agreement and other document, and I did it on good faith.
Till then,
My
there
lord,
was no.
till September there is no problem. Once the timeline is breached, my lord, you make a complaint. Your lordship has seen the WhatsApp messages also, my lord.
Now, what is the grievance of the first informant that you have not executed?
Timely.
And he has not paid the rest of the amount.
Lord, rest of the men at the time of execution of sale deed, my lord. How can I pay them without execution? My lord, will kindly look into, my lord, these judgments I am relying upon, my lord. On similar facts, the other side has in fact lodged an FIR. The apex, this honorable court has passed that. Lord, I have to satisfy your lordship that from the very beginning
420 and 468.
My lord.
468 is there.
But 468, she's saying that she has
have put
given.
my signature. And not only her, my lord, her co-pattadars have also signed. They have not made any allegation. They have not lodged any FIR.
Okay.
Had it been her own single land, my lord, perhaps something would have been done. Now, my lord, I should rather file a FIR against her, my lord.
But her subsequent action, because the circle officer also called him by summons and all, and he did not appear.
No, but
No, why did the circle officer have jurisdiction to entertain that, my lord?
heard Mr. R. Dubey, learned counsel for the petitioner, also heard Miss S. Jahan, learned additional public prosecutor. This application under section 482, right, section 401 of the Code of Criminal Procedure, Command 1973, has been filed by the petitioner Pinku Medhi, praying for quashing the FIR dated 7/10/2023, filed before
Otherwise, accept that.
Palashbari Police Station, on the basis of which Palashbari PS case number 394/2023 has been registered. The
Other
in
signature
the
was
impugned FIR, the one Srimati Alaka
This
Mali
is NOC.
Yes, this is that. Computer generated.
has alleged that the present petitioner has
She is Alaka Malik.
Yes.
that the present petitioner approached the first informant to with to purchase the land of the first informant measuring 9 kathas covered by KP Patta number 1 under Dag number 376 of Magurpara village under Sayani Moja of Palashpadi Revenue Circle. It is also alleged in the FIR that a deed of agreement was executed between the first informant and first informant and the present petitioner, wherein the first informant had put her signature on good faith and the consideration amount for sale of the said plot of land was fixed at
8,10,000, madam.
Eight.
That is also.
Here,
one
but
method.
9 lakh 9.
Madam, we'll see the original agreement, 4,50,000 per bigha.
But consideration amount was fixed at 9,90,000. Out of which the petitioner is stated to have paid 2 lakhs as an advance on 25/2022 and thereafter he had not paid the remaining amount of money. It is further alleged in the FIR that the first informant thereafter filed a complaint before circle officer to cancel the NOC which was granted by the deputy commissioner, and the circle officer showed his inability to do the same and advised the informant to lodge an FIR and approach the deputy commissioner for seeking necessary relief. It is alleged in the FIR that the present petitioner is a land mafia and has cheated the first informant and has forged the documents by taking the signature of the first informant on the stamp papers in the name of deed of agreement. Learned counsel for the petitioner has submitted that the petitioner has misrepresented the facts in the impugned FIR. In fact, the informant has misrepresented the facts in the impugned FIR. In fact, the informant is not the sole owner. She is rather the joint owner of the land which was intended to purchase by the present petitioner. And in there, you had the agreement with other co-pattadar.
Yes, there's one common agreement, my lord.
And accordingly, an agreement was entered into with all the pattadars,
Please 16 your lordship would-
including the first informant, at a total consideration amount of rupees 8,10,000, out of which rupees 50,000 was paid by the present petitioner as an advance installment.
Subsequently, we paid 1,50,000 further, my lord.
Thereafter, learned counsel for the petitioner has further submitted that thereafter the petitioner again paid 1,50,000 in 3 different installments. 3 installments.
To the 3 pattadars.
1,50,000 to 3 different pattadars. And thereafter they jointly along with the petitioner jointly along with the first informant applied for land sale permission before the Deputy Commissioner Kamrup Amingao. And in support of the said contention, a photocopy of the application for sale permission has been annexed along with the present petition. It is further submitted by learned counsel for the petitioner that in this regard, an affidavit as required under section.
Look,
No.
this NOC is issued under
No,
section
an
21A.
affidavit, a joint affidavit was also affirmed by the present petitioner
For obtaining sale permit.
as well as the informant Srimati Alka Medhi for obtaining and other co-pattadars for obtaining the sale permission. And accordingly, on 23rd of August 2022, sale permission was granted by the office of the by the Deputy Commissioner Kamrup Metro.
May I make one clarification? My friend has confused us regarding this. It's a computer generated issued by Deputy Commissioner. There is no requirement of any signature on this.
I thought the sellers needs to sign, but then perhaps it's not there. So that 468 will not stand. In fact,
Does not, now it does not appear.
as of now. Because she had already put her signature in good faith. That is clear that.
After
420, of course, again.
learned
It's a very
counsel,
initial.
learned counsel for the
exception and all.
petitioner further submits that the petitioner intends to honor the agreement, honor the agreement which was executed by him and the informant and other co-pattadar. However, due to some difficulties faced by the petitioner, the deed of the sale deed could not be executed in due time. However, in the meanwhile, the petition, it is further submitted by learned counsel for the petitioner that in the meanwhile, the petitioner had made telephonic communication with the first informant, wherein on November 17,
These are the messages. These are WhatsApp messages.
November 17, he offered to the petitioner to come to her house along with the required documents. However, the informant herself asked the petitioner not to come as proposed by the present petitioner. In support of his submission, the learned counsel for the petitioner has pointed out to the screenshots of the
WhatsApp message.
WhatsApp messages between the petitioner and the informant, which is annexed as annexure number 7 to the said petition. Learned counsel for the petitioner has further submitted that no ingredient of alleged offense under section 468/420 is made out in the FIR, and the FIR has been lodged by the petitioner by the informant only to harass the present petitioner. Issue notice to the respondents as respondent number 1 is as learned additional public prosecutor has already appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD returnable after 4 weeks. These steps shall be taken within 3 days from the date of this order. In the meanwhile, as apparent from the the materials placed before this court along with the criminal petition, it appears that there was a agreement deed between the informant as well as the present petitioner, and the informant does not appear to be the sole owner of the land, which is the subject matter of the dispute between the parties, as claimed by her in the first information report. Further, considering the submissions made by learned as well as considering the submissions made by learned counsel for the petitioner, what relief you are seeking?
For a stay of the investigation regarding that.
Although there is nothing to object, Lordship will write one line objection as far as I'm concerned. That's the ingredients of 420 are seen by his subsequent actions.
With due respect, Lord, ingredients of 420 should be at the initiation.
No, yes, by his subsequent action, we can
Subsequently,
reduce
there
the
is
inception part.
that
What was the last?
There's nothing actually.
As well as materials available on record, further investigation of Polaswari PS case number 394/2023 is hereby kept in abeyance
We can say.
till returnable date. Till
Lordship,
returnable.
I'm so deeply okay.
Lordship has fixed some date in it.
4 weeks, no date.
4 weeks, Lordship.
I'm okay.
Lordship.
Hearing PA item number.
Admission will take long hearing. So it will be up.
Only 5 minutes, a very small issue. A very small issue.
It is unlikely that admission, it is for final disposal.
Yes, it can be disposed of finally because the proceeding is pending here.
After bail hearing.
After really unlikely to be.
Because otherwise, I have experienced that if we go for admission, final hearing, the bail matters are put to halt. 5 minutes becomes 50 minutes. So after bail hearing, we will take it.
Item number 14, there is.
If it is not for final hearing, we may take up.
It after. Lordship.
If it is for final disposal, then after bail hearing. Because bail hearing will not take much.
Very small issue. In case there is no likelihood that after 2 months, 3 can be taken up.
Okay, we'll try to finish off the bail
I
matter
can
first.
also explain that some matters are not being reached.
Because after completion of bail matter, we'll take up.
No, my question, ultimately, has a question.
At 3, you may try.
The LCR is here. I have to kind of look into, but I think they have filed one affidavit.
Lordship, may I please, Your Lordship? On last occasion, Your Lordship has inquired about the last rejection order, Your Lordship, that was rejected, which I have annexed and filed on my additional affidavit. And my learned counsel on the other side for the informant also raised an objection regarding filing of the bail petition, Your Lordship. Lordship may take up my additional affidavit at page number 47 onwards, Your Lordship.
No, what is the matter?
Lordship, the FIR is at page number 14, Your Lordship. This is a charge-sheeted case, Your Lordship.
Under section?
302, Your Lordship. The
So-
informant herein is my uncle, Your Lordship, and the named accused is my auntie.
Okay.
I'm not named in the. One four zero.
Okay. 302. Thereafter, charge sheet was laid
Lordship.
against
The both accused, your lordship,
against Salma Jahan.
and the present accused, your lordship.
What is your name? Mohibul.
Mohibul, your lordship.
Thereafter, at what stage the trial is pending?
Total 18 number of witnesses are there, your lordship. At present, almost 10 witnesses are examined, your lordship. You are not there in the LCR. I have annexed in the additional affidavit, your lordship. All the depositions. Because LCR was called on the previous day, your lordship.
Okay.
At that time, at the time of filing of this bail application, there were 5, your lordship. Now 10 has been examined, your lordship. No implication on my part, your lordship.
Okay.
Yes, only the informant has said, lordship, I will take the implication part.
At page?
Page number, your lordship, 62, PW6, your lordship. Of my additional affidavit, your lordship. Lordship, the third paragraph, your lordship. May I read, your lordship?
Yes.
After filing the FIR, I could know from the Gaubra Sokot Ali Sikdar that my wife has confessed before the public that she had an affair with Mohibul Ali, and on the day of incident, Mohibul Ali caught hold of legs of mother while my wife Salma pressed the face of my mother, your lordship. Your lordship, may also see the deposition of PW2, that is the Gaubra. That is at page number 37, your lordship.
Now, where is the Salma is in jail?
Yes, your lordship. Both are in jail, your lordship.
Okay.
Lordship, my age is 21 years, your lordship, and Salma Jahan is my auntie. Her age is 32, your lordship. And I am arrested only on the basis of testimony of the co-accused, your lordship. Your lordship knows, your lordship, the testimony of the co-accused cannot be relied upon, although it is a matter of trial, your lordship. And almost 10 witnesses has already been examined. And rest other witnesses has not repeated anything about the other.
How many total number of witnesses?
Total 18 witnesses are there, your lordship.
Who are left now?
Lordship, at page number 22 is the staff with your lordship. Lordship, the independent witnesses are examined also. Only your lordship, IO and all, they will left out, your lordship. The list of witnesses at page number, your lordship.
Page?
Page 20, your lordship. Page 20 is the list of witnesses, your lordship.
Yes.
Independent witness.
PW number 2, he said about some extrajudicial confession made by the wife, Salma, and who had taken the name of Mahibul. But then perhaps the police was there when this confession was made. Then in that case, it will be hit by 24. PW6, he had also heard. PW10, sir? PW10?
10.
No, it's not. Oh my God.
No, otherwise, assuming that
Hmm.
some implicating evidence is there against him.
Huh.
Out of 18 witnesses,
Hmm.
then 8 are already examined.
Hmm.
8 are examined.
10 are examined, Your Lordship.
And you are behind the bar since
263 days, Your Lordship.
when? Which date?
2/3/23, I was arrested, Your Lordship.
Since 263 days.
3 days, Your Lordship.
Hmm.
So what is the justification of keeping him detained if he is ready to face trial?
Hmm. And the trial is going on.
You are opposing.
Lordship.
You are for the informant.
I'm for the informant matter. The victim is this is my mother and the accused Salmajan is my wife, my lord. He actually killed my mother.
No, that trial will reveal.
Lordship.
Now, why are you opposing now?
So there is direct allegation against them, my lord.
No, the ground should be,
From the
he may flee away from the,
Hmm.
that if that apprehension is there, or he may temper the evidence, but the most of the evidence are already there.
I'm a
Yes,
student,
but,
Your
my
Lordship.
lord, I leave to you, my lord. On the other hand, my lord, in the medical report also, postmortem report also, my lord.
No, your ground is that there are incriminating material.
Lord.
Apart from that, other ground, any other ground that he may intimidate. There is no other ground for a plea.
Already, my lord, most of them examined.
Okay. Let him face.
Go on there.
Heard Mr.
S.A. Hussaini.
S.A. Hussain, learned counsel for the petitioner. Also heard Miss S. Jahan, learned additional public prosecutor, as well as Mr. H.A. Ahmed, learned counsel for the informant. This application under section 438, 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mohibul Haq alias Mohibul Ali, who has been detained behind the bar since 2nd of February 2023 within bracket 206 since last 263 days in connection with sessions case number 98/2023 arising out of Satyabari PS case number 47/2023 under section 302 of the Indian Penal Code. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged by one Jahirul Islam on 2/3/2023, the present petitioner was arrested on. No, you were since detained behind bars since
2/3/2023.
2nd February, no, 2nd March. Since 2/3/2023. And after completion of the investigation, which started on the basis of the aforesaid FIR, the charge sheet was laid against the present petitioner and one another co-accused, namely Salma Jahan Ahmed. It is further submitted by learned counsel for the petitioner that out of 18 numbers of listed witnesses in the charge sheet, 8 are already examined.
10. Lordship, 10.
10 are already examined, and most of the official witnesses are only remaining to be examined. It is further submitted by learned counsel for the petitioner that the petitioner is a permanent resident of village Kamalabari under Satyabari police station, and he is ready to face trial and shall cooperate in his trial. On the other hand, Mr. H.A. Ahmed, learned counsel for the informant, has opposed the grant of bail to the present petitioner on the ground that there are serious incriminating materials against the present petitioner, and the present petitioner, in connivance with the wife of the informant, killed the mother of the informant.
One thing, my lord,
They, after filing this petition before this honorable court, my lord, they by suppressing that fact, they moved another petition before the session judge. My lord,
I have brought in record,
without,
Your Lordship,
without
filing a additional affidavit.
What you have stated?
Lordship.
suppressing everything, my lord. It is
Learned counsel for the petitioner,
56. my lord,
learned
for the-
counsel for the informant has also submitted that the petitioner, after filing this instant bail application before this court, had also moved an bail application before the Court of Sessions, wherein the fact of filing this instant petition was suppressed. Therefore, that petition would be rejected.
That was
It
already
would-
rejected.
That was already
It would not affect this petition.
They are not clean.
It is a
hands, my lord.
good ground for rejecting that petition.
But
On the other hand, learned counsel for the petitioner submits that the present counsel was not knowing on that day you made a submission that some,
Lordship, at page number 47, I have stated.
What-
That
what-
was filed without any authority, Your Lordship. Immediately I have changed the advocate also on that day, Your Lordship. That petition was not supported by affidavit also, Your Lordship.
where is the,
Page number 47, Your Lordship, paragraph 4, Your Lordship.
on the other hand, learned counsel for the petitioner has submitted that the petition for bail filed before learned Sessions Judge Borpeta was not filed with any authority from the present petitioner, as it was filed without any wakalat number. And in this regard, the petitioner has also filed an additional affidavit before this court. Stop. I have considered the submissions made by learned counsel for both sides. It appears that out of the 18 listed witnesses, 10 listed witnesses for the prosecution side have already been examined. And considering the long period of detention, that is 263 days, as well as considering the fact that the petitioner is ready to cooperate in the trial, his further custodial detention, and also considering the fact that apart from the submissions that there are incriminating materials against the present petitioner, learned counsel for the informant has not made any other apprehension like possibility of tampering of evidence by the present petitioner or fleeing away from the course of justice by the present petitioner. Under such circumstances, this court finds no justification for keeping the present petitioner behind the bar during the remaining course of trial. Therefore, in view of above, the petitioner, namely Mohibul Haq alias Mohibul Ali, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Sessions Judge Borpeta, with a learned Sessions Judge Borpeta, who may impose any condition at the time of releasing the accused petitioner on bail if he deems it fit to do so. With above observation, this bail application is hereby disposed of.
Item number 15.
May I please it? Well, this is 439 application, my lord. This is submitted matter, my lord. Elsewhere was called for, further item has been received, my lord. I am behind the bar since 158 days, my lord. My lord, the case has been committed on 14/8/23. Last date of framing charge was on 14/11/23. Charges are not yet framed, my lord. There are total 28 numbers of
When
witnesses.
it was committed,
My lord, 14/8/23. And last date of framing charge was 14/11/23. Charges are not yet framed, my lord. There are
Since when you are behind the bar?
148 days, 15/6, my lord. 15/6/23. 158 days, my lord. My lord, there are 28 numbers of witnesses, my lord.
What is the offense?
My lord, offense is under 341, 325, 323, 307, 34 IPC, my lord. The fact of the case is that my lord, petitioner teaches some girl student, my lord. As such, the victim prohibited them not to teach them. And finally, altercation happened, my lord. They sustained paper injury. So far as the medical report, my lord. My lord, where the permanent resident, my lord, if it is normally goes, my lord, another 3-4 years will take, my lord. As because there are 28 numbers of witnesses. So, my lord, at any condition, my lord, we will participate in the trial, my lord, we may be allowed to go on. FIR is at page number 9.
You teased girl student.
My lord, that is the step. That is the allegation, my lord. My lord, we are the marksman by profession, my lord. Rather, they have, my lord, some options were used against.
No, if you are released on bail, what is the assurance that your conduct will remain?
My lord, we are mason, my lord. By profession, we are mason, my lord. So, my lord, we are hailing from Goalpara district, my lord. So, there is no question arises, my lord. We will participate in the trial, my lord.
Okay, trial is going on in Sibsagar.
My lord. After teaching, the question of after teaching does not arise at all.
No, that was not the main question. What is the assurance that you will face trial
At any condition, my lord.
in Sibsagar?
My lord, at any condition.
What
Imposed
condition?
by
What condition?
any stringent condition, my lord.
The petitioner is hailing from Goalpara.
Goalpara, local, my lord.
Otherwise, allegations of assault is also there. He assaulted with wooden logs.
My lord, if it is true, my lord, then 307 will not come. 325 will
Charges are
come, that
yet
is
to be
available.
framed, Lordship. Kindly let the
320.
charge be framed at this stage.
My lord, kindly see the FIR. There is no elements of 307, my lord.
No,
My
how
lord,
to ensure that
at any condition, my lord.
you suggest how you're ensured.
Each and every date we will appear before the court, each and every date, my lord. We will not meet.
Because normally the experience in the sessions courts are if the accused are from
We will not
other
leave the
districts,
jurisdiction
it
of
is very
State
difficult to procure the attendance.
My lord, without prior permission of the court, my lord, we will not leave the jurisdiction of the state. Additional condition.
Yes, Ms. Bora.
Lordship, at this stage, I am objecting again.
How many witnesses are there?
28. Page number 25, my lord. List of witnesses.
Third, Mr. A. Parmani, and counsel for petition. Also heard Ms. S. H. Bora, the petition. This application under section 439 of the Code of Procedure 1973 has been filed by petitioners, namely Safiqul Islam and Rokibul Islam, who are detained behind the bar since 15/6/2023, within brackets since last
158 days.
58 days, in connection with sessions case number 87, within bracket SS/23, pending before the Court of London. Sessions Judge Sibsagar arising out of Hello Worthing PS case number 21/23. Learned counsel for the petitioner has submitted that the present petitioners are facing trial in sessions case number 87/23, which is the result of which was registered after the committal of PR case number 181/2023 by the state court. The charge sheet in the state case was filed under section 3. Charge sheet in the state case has been filed under 341/325/307/34 of the IPC. And the case was, and the entire criminal law was set in motion in this case by filing of an FIR on 15/6/2023 by one Shri Arun Thakur before the officer in charge of Howlating Police Station, inter alia, wherein it was inter alia alleged that the present petitioners had on 15/6/2023 teased some of the students of Amgori Howlating Mazdoor High School, wherein the grandson of the first informant along with some other boys intervened, and they were assaulted by the present petitioner. Learned counsel for the petitioner submits that the petitioners are innocent. It is also submitted that the petitioners are Mason and they went to Sibsagar for their livelihood. It is further submitted that though the petitioners are detained behind the bars since past 158 days, and the case was committed to the Court of Sessions on 14/8/2023. However, charges are yet to be framed. It is further submitted by learned counsel for the petitioners that there are 28 numbers of listed witnesses in the charge sheet, and there is a likelihood that the culmination of trial would take a considerable long time, and as the petitioners are ready to face trial under any conditions which may be imposed by the court, there may not be any justification to keep them behind the bar during the entire period of the trial. During the pendency of the trial. On the other hand, an additional public prosecutor opposed the grant of bail to the present petitioners on the ground that the charges are yet to be framed and main witnesses are yet to be examined. It is further submitted by the additional public prosecutor that the present petitioners are the permanent resident of Walpara, and the trial is going on in the district of Kamrup. Sibsagar. And there is a likelihood that there it would be difficult to procure their attendance during the pendency of trial if they are released. Stop. I have considered the submissions made by the counsel for both the parties and have considered the and also have perused the scanned copy of the case record of Sessions case number 87/2023, which was called for in connection with this case. Stop. It may not be justified to keep. It does not appear to be justified to keep the present petitioners behind the bar merely because of the fact that they hails from a different district and the trial is going on in a different district. If they otherwise cooperate in trial. It also appears from the record that though the petitioners are detained behind the bar since last 158 days, the trial has not yet commenced. And considering the number of witnesses listed in the charge sheet, there is the likelihood that the culmination of trial would take considerable period of time. And therefore, if the petitioners cooperate in the trial, they need not to be detained behind the bar. This court is of considered opinion that they need not to be detained. In view of above, both the petitioners, namely Safiqul Islam and Rotibul Islam, are hereby allowed to go on bail of rupees 30,000 each with one surety of like amount to the satisfaction of learned Sessions Judge Sagar with following condition. Number 1, the petitioners shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses of the Sessions case number 87/23 or any other person who may be acquainted with the facts of the case so as to dissuade such persons from deposing against the petitioners in the pending trial in Sessions case number 87. Number 2, what conditions may be imposed at forum? Number 2, the petitioner.
These are the conditions for
the
present when required.
The petitioner shall not leave the jurisdiction of Sibsagar district
Yes.
without prior leave of the learned trial court. Learned trial court, where the trial is pending. Number 3, learned trial court may impose any additional condition.
Yes.
In addition to the condition imposed by this court, if it deems fit to do so. With above observation, this bad application thereby.
Not 439 application, my lord. Today is the 76th day. After the, my lord, 436 IPC is the, my lord, allegation. Page 12 is the fire, my lord. Mischief with fire or.
Kesari has read.
CD has not arrived.
My lord, the 76 days, my lord, if go to the fire, my lord, there is no mention about that, my lord. These are family members and drunken says he was admittedly excited by this provocation. Then mischief was done, my lord. So here it mentioned the firearm, but in a forwarding report as well as in FIR, there is no mention which firearms. And then one incident is alleged that one low category vehicle that was set fire, and acquisition is okay. So by wooden firewood, my lord. But there is also dispute, and he was a drunkard.
We need, I'm praying for another short date, but is the case.
Government employee, my lord, without
his job has been gone, my lord, and 76 already, my lord.
Lordship, section IP6,
90
the
days, only
previous
14 days
office
left for
authorized.
90 days.
Kindly give us 1 week time of.
Last occasion of.
Because sections are serious.
One section, my lord. Other section, my lord, and also they
Otherwise
have,
also-
What firearms you have used?
no, it is not mentioned, my lord. Only firewood and set fire. That is vehicles, one vehicle was set fire. I don't know he has set fire or not, but it was.
Otherwise, mandatory period of detention is 90 days.
Vehicle has been set on fire. Which vehicle? What vehicle has been set?
As per section, my lord, explosion with building, my lord, mischief by explosive substance or fire. with
No,
building.
I'm querying, I'm putting query as to
My lord, it
what is the allegation against you?
Yes, first allegation is he has done some threatening work with weapons, but weapons was not mentioned. What type of in forwarding letter, that is not mentioned.
Okay.
Second part is that one vehicles was set fire by wooden fire. Wooden fire is brought from the kitchen and then set fire, my lord. This was the second part of allegation. And admittedly, he was in drunken state. He was provoked, excited, and in forwarding report, it is said that he confessed his guilt. This was the forwarding report's material, my lord. Otherwise, nothing else.
You
And
should kindly
if-
turn to page 19, the redaction order of the Bonnet trial.
No, he has been detained behind the bar since 76 days.
Lordship,
When can you bring the case?
any short day possible. Will produce it.
Earlier also date. was-
Yes. Last one chance may be given.
When?
Lordship is from Bongaigaon. Lordship, can it be on 27th, Friday?
Let us see.
Lordship,
Third, Mr. M.J. Borwa, and counsel for the petition.
no. Okay, then Lordship,
Before that,
before that, Lordship. Last Friday, Lordship, 24th.
third, Mr. M.J. Borwa, and counsel for the petitioner. Also, heard Ms. S.H. Bora, and an additional public prosecutor who submits that though the case diary was called for, however, same has not been received, and she prays for one another chance to produce the case diary. The prayer is allowed. That is 24,
Highly agreed.
24/11. For case.
May please your vote. But the petitioner was arrested on 14/10. Today is 38 days, madam. Last occasion, my lord, the case diary was called for. Initially, my lord, case was
302 was added later on. okay?
added 302. The
Lordship,
present
we need the
petitioner is
case
not naming
diary.
the affair.
CD is not available.
CD is not there.
Not available.
CD would be required.
Yes.
302 may.
It's not that kind of, because
Heard Mr. N. Udain, learned counsel for the petition. Also heard Ms. S.H. Bora, who prays for another date for producing the case that the prayer is allowed. Let this case
I
be
thought that-
listed again on
11th. No, first of December.
1st of December.
Item number 9.
Wait, so for 39 application, Lordship will find the vernacular FIR page 60. On the occasion of Lakshmi Puja, some of the two-wheelers, they parked their two-wheelers in front of my flat and prevented me from running my shop. I complained to the Puja committee accordingly informed the police, and there was some altercation. The police personnel, they manhandled the petition number 1. The daughter of the petition number 1, he tried to videograph the entire incident. And accordingly, on being influenced by the police, the Puja committee laws and the persons who had the altercation with the petition number 1, the bikers, they did not file any laws, any effect. May I read the FIR?
CD was called for that we have not received. Lordship. Let it be on 28.
No issue, Lordship, because of
28/11.
the congestion of traffic congestion on the occasion of Lakshmi Puja.
Short date.
2811 Lordship,
28.
Heard Mr. Z.
24
Heard Mr. Z. Alam, learned counsel for the petitioner, also heard Ms. S.H. Bora, learned additional public prosecutor, who prays for another date for producing the case that prayer is allowed. Let this case be listed
right.
on 28.
Declare.
Item number
Order, my lord, is at page number 21. He was granted bail on 11/8/2023. Thereafter, my lord, after being released on bail, he again kidnapped the minor daughter of the informant, my lord. Then, my lord,
Rajkumar Chauhan.
yes, then, my lord, this present FIR was lodged, my lord. This present FIR, my lord, is at page number 28. Is at page number, my lord, 27.
You are not Rajkumar.
No, my lord, I am his friend, my lord. 27, my lord. The present FIR. May I read, ma'am? আজি ইংৰাজী 26/9/23 তাৰিখে দুপৰীয়া 2মান বজাত মোৰ ভাগিন ছোৱালী ৰশ্মি চৌহান পিতা ৰাম বাহাদুৰ চৌহান থানা লংকা জিলা হোজাই মোৰ ঘৰত থকা অৱস্থাত উক্ত ৰাজকুমাৰ চৌহান আৰু চন্দন চৌহান নামৰ ল'ৰা দুজনে এখন মটৰচাইকেলেৰে আহি অপহৰণ কৰি লৈ যায়. So that is the allegation, my lord, and that FIR was registered under 366A. Thereafter, my lord, the petitioner was arrested on 29/9/23, my lord, and since then, my lord, he has remained in custody. So, now, my lord, the thing is that the maximum period of detention in 366A is 60 days, my lord. He has already completed 52 days in custody. The girl, yes, the girl and the boy is yet to be recovered. They have eloped. They are not. The girl is not recovered.
And Rajkumar is also not.
Yes, he is also absconding. But I am without any ground, my lord, I am behind.
All witnesses are hearsay, Lordship. They say that, my lord, they have heard that the girl, my lord, eloped by Rajkumar Chauhan and this petitioner, Lord. Then he was arrested, but Rajkumar Chauhan yet to apprehend, and the victim girl is not yet recovered. That is the, my lord, progress of the investigation.
What the investigation, whether his detention would be required?
No, that his statement recorded, Lordship, because he also said, Lordship, that they eloped, Lordship, but where they had gone, where they are staying, he does not have any knowledge.
Whether he said that he participated in.
That he has not stated in his statement.
Then let him continue to cooperate in his detention. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. R. Borba, an additional public prosecutor. This application under section 413(9) of the Code of Criminal Procedure has been, 1973, has been filed by one Chandan Chauhan, who is detained behind the bar since 29/9/2023, within bracket since last 52 days, in connection with Kaki PS case number 96/2023 under section 366A of the Indian Penal Code. The gist of accusation against the present petitioner is that on which date the FIR?
My lord, on 26/9/23, the present FIR was lodged, my lord.
On 26/9/23, the father of the victim girl,
this FIR was lodged by the uncle, my lord.
The uncle of the victim girl, namely
Kola Chauhan.
Kola Chauhan, lodged an FIR before. Where is the FIR?
But 27, my lord, page number 27.
Before the officer in charge of Kaki Police Station, inter area, alleging that on 26/9/2023, the present petitioner, along with one Rajkumar Chauhan, had kidnapped the niece of the informant, and thereafter the whereabouts of victim girl is not known. So, learned counsel for the petitioner has submitted that prior to the present incident on an earlier occasion, that is on
5/7, madam.
5/7/2023 also, the niece of the informant
Yes.
of the present case was kidnapped by the co-accused of the present petitioner, namely Ramkumar Chauhan. Rajkumar or Ramkumar?
Rajkumar Chauhan.
Rajkumar Chauhan. It is further submitted by learned counsel for the petitioner that on earlier occasion the accused Rajkumar Chauhan was granted bail by the learned Sessions Judge Hojai. However, thereafter the niece of the informant again eloped with the said Rajkumar Chauhan, and both the victim girl as well as the co-accused Rajkumar Chauhan are, and whereabouts of both the victim girl and Rajkumar Chauhan are not known. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bar since last 52 days. And what is your submission as regards your participation?
My lord, my instruction is that, my lord, this main accused, my lord, Rajkumar Chauhan, he requested the present petitioner to drop him at the house of this girl, my lord. Thereafter, my lord, he does not know. He returned back to his home. He does not know what happened after that, my lord.
Learned counsel for the petitioner has also submitted that on the request of the Rajkumar Chauhan, the present petitioner only dropped him in front of the house of the victim without knowing as to the intention of the co-accused was to kidnap the victim girl. Stop. Learned counsel for the petitioner has also submitted that the petitioner would otherwise cooperate. On the other hand, learned additional public prosecutor has produced the case diary of Kaki PS case number 96/23 and has submitted that the main accused, namely Rajkumar Chauhan, as well as victim girls' whereabouts are yet to be known, yet to be recovered, yet to be known, and the victim girl is yet to be recovered. It is further submitted by learned additional public prosecutor that the investigating officer has recorded the statement of witnesses whose testimony is only hearsay in nature. It is further submitted that the investigating officer has also recorded the statement of the present petitioner under section 16 of the Act. Considering the progress made in the investigation, though the victim girl is yet to be recovered and main accused is yet to be apprehended. However, considering the fact that the statement of the present petitioner has also already been recorded and he has been detained behind the bar since last 52 days, his further custodial detention does not appear to be necessary for fair completion of the investigation of the case if he otherwise cooperates with the stop. In view of above, the petitioner, Shri Chandan Chauhan, allowed to go on bail of rupees 30,000 with one security of like amount subject to the satisfaction. Learned Chief Judicial Magistrate Hojai. with a condition that he shall cooperate in the investigation and shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair completion of the investigation. With above observation, this bail application is hereby
Highly obliged. 21 and 22 from the same police station, my lord, same. Case diary was called for, my lord.
That's right.
Case diary is given.
Yes.
It's a bit, my lord, from the case diary. My lord, case diary, my lord, received, my lord, along with the postmortem report received. But postmortem report is not final because, my lord, my lord, chemical examination report is yet to collect. So for this reason, Lord, say, may I request some more time may be granted to produce the matter chemical analysis report because this is important. Lord. So allegation is that she committed suicide.
No, but there is no allegation that she was administered poison.
No, that is why, Lord, say, postmortem report is necessary. Lord. Final outcome of the report is not present.
No, even if she was administered poison,
My lord.
he was in jail. The petitioner was in jail when she died.
My lord.
So otherwise, the postmortem report says that she died by hanging.
No, she jumped from the building. Lord.
Or jumped from the building.
My lord. My lord.
No, is there anything in the case diary which suggests that he has either abetted or instigated?
My lord,
Anything to
my lord,
suggest?
statement of the witnesses, my lord, stated before the investigating officer, he was not aware that this accused person, they were running this business. Lord. When she came to know about the, my lord, business of the accused person, and they are arrested or supposed to be arrested.
Which business?
My lord, they were connected in, my lord, the cyber crime, Lord, wherein they used to call the people of the various countries and, my lord, they, to their source of the income some money which is illegal. Lord.
A separate case has been written.
Yeah, that is under investigation. Lord. So
She
when
was
came
also
to
an
know-
accused.
No, she was not.
She was working in the.
But she was working in the farm of this two petitioners. Lord. And when she came to know that this petitioner was supposed to be arrested, already arrested, Lord, then she committed suicide.
She was also apprehending arrest.
No, that is not clear from the case diary. Lord. But she, my lord, there were some rotative, my lord, apprehension in her mind, probably that is why. Because her owners, rotative, they are the accused person in the, my lord, cyber crime.
No, the question before this court is now is whether the allegation that the petitioner instigated and abetted is there any material? Some material.
Direct materials are not there. From the so far the investigation is going on.
Then on what basis the police officer lost the FIR? Police officer had
Yes,
lost
police officer lost the FIR because Lordship, he committed suicide out of fear. Lordship. And probably Lordship, he has, my lord, stated some other person. Lordship.
Yes, that I want to.
Yes. But this is the mother statement of the one of the witnesses.
What is the name of petitioner? Rajan.
Yes.
Siddharth.
Rajan Siddharth.
And in other case?
Mohendra San. Mohendra.
Okay.
This is the amount of material.
Yes, Mr. Yeah.
Yeah,
What is your sub?
my submission is very limited, my lord. This girl died out of fear of arrest. In paragraph 9, I have specifically stated, my lord, the deceased was picked up by police in connection with cyber PS case number 8 of 2023, and she was subsequently released on signing a bond on 15/9/2023. And it appears that the reason for her committing suicide is because she was arrested by police. That is the reason of fear. Now, my lord, kindly see the affair itself.
No, no, no. Where? Para?
Para 9. Para. She was arrested. She was released on bond in connection with that case.
She was also arrested.
Yes, released on bond. And my lord will kindly see the affair itself at page 8, wherein after the cyber PS case number and the address given, it's been specific in the case itself, my lord, affair itself. The deceased so-and-so 24 years, so-and-so, was working as service representative in the call center, so-and-so, situated at so-and-so. She was staying as a tenant in so-and-so, situated near government place, Bamuni, and the said flat was in the name of accused of this case, namely, this is incorrect, man. I don't want any flat in Guwahati. And during investigation also, they cannot collect anything, man. The deceased so-and-so was working in the said establishment at the instigation of the above two accused persons to gain more profit by thinking the said establishment as legal. Although the deceased was engaged in the said institution and knowing about the arrest of Ranjan Sidana in the cyber PS case number so-and-so, and Mahendra Sen under apprehension of arrest in the instant case, and also under apprehension to lose her reputation, she committed suicide. So, abatement to suicide with regard to the commission of the offense of suicide. Suicide itself is an offense. For that purpose, for committing suicide, I have to aid that person in commission of suicide. I have to instigate her, you commit suicide. I have to engage herself in the commission that I provided the gun or provided the rope. And that's been the law with regard to 306. Now, I have to avail a loan. I have been financial distress. I cannot repay the loan. I commit suicide. Suicide itself is a disease. My lord, a normal person cannot do it, my. And here is a case, my lord, wherein there is, even from the record itself, I show, my lord, at page 17, 15/9 at 7:30 p.m. previous day, he was in police custody. So my abating her suicide by instigating her to commit suicide, my to aid to commit suicide, my engagement in the commission of suicide doesn't arise itself. My lord, absolutely no case. There has been a judgment, my lord, of our High Court, wherein in a quashing petition, my lord, a person, namely, my lord, Akaki Tora, here, and Akaki Tora, she's been an anchor and conducting a TV show, my lord, within a time frame, my lord, in a channel called DY365, Zcom Hosacom. Now, the plea taken by this, in that particular case is this, that the son doesn't look after the mother. The live show was conducted. Mother was in old age home and the daughters was also there. Now, everything was being described live. Thereafter, what happened? The mother said that my son doesn't look after me and all such things. Now that program ended. Thereafter, this particular person who committed suicide came to DY 365 studio and requested that I am going to take back. You all again organize a TV show. Then again a live show was organized and the mother was taken live. She said that I have apprehension of life. He may kill me. I will not go back. And thereafter, that program concluded. Now, this particular gentleman came to Guwahati and went back to my lord Lakhimpur. And by writing a suicide note, he hanged himself and my lord, thereafter he died. And 306 case was registered. And in that case, my lord, the law with regard to 306 has been appreciated. I take this honorable court, my lord. The factual position I have taken in, my lord, that at page 4, my lord, will kindly see 306 has been discussed. Yes, para 7, my lord, 306 that has been discussed. Then 107 ingredients has been discussed, my lord, paragraph 10. And Supreme Court judgment has been discussed.
Where Supreme Court judgment?
May I read from my lord,
Okay.
page 4, my
Page
lord?
para 6.
Para 6, my lord, is with regard to the allegations, my lord, and the law with regard to this, my lord. RP Kapoor's case and everything has been discussed. If I take your lordship to paragraph, my lord, page 4, wherein, my lord, at paragraph 7, my lord, will kindly see 306 has been discussed. And paragraph 8, my lord, is Supreme Court judgment has been discussed. Madhya Pradesh High Court judgment has been discussed. And a Supreme Court judgment also been discussed. Paragraph 10, my lord, 107, my lord, the ingredients. Abatement to suicide. What is abatement? Constitute abatement. This has been discussed. Paragraph 10. At page 5, my lord, will kindly come to, my lord. Paragraph 9 again, it's been shown that way, my lord. Similarly, a case of Ramesh Kumar versus so and so, instigation is to good, urge, forward, provoke, incite, or encourage to do an act. To satisfy the requirement of instigation, though it is not necessary that actual word must be used to that effect, or what constitutes instigation must necessarily and specifically suggestive of the consequence, yet a reasonable certainty to incite the consequence must be capable of being spelled out. The present one is not a case where the accused had, by his acts or omission or by a continued course of conduct, created such circumstances that the deceased was left with no other option but to accept to commit suicide, in which case of instigation may have been inferred. A word uttered in a fit of anger or emotion without intending the consequence to actually follow cannot be said to be instigation. In case of so and so, my lord, the allegation was that the appellant had used abusive language and had reportedly told the deceased to go and die. And it was held that even if the prosecution is accepted story that the appellant had asked the deceased go and die, that itself will not constitute an ingredient to instigate. Now, the word instigate denotes incitement or urging to do something drastic or inadvisable action, or to stimulate or incite. Presence of mens rea, therefore, is the necessary concomitant of instigation. It is common knowledge that the word uttered in a quarrel or under the spur of the moment cannot be taken to be uttered with mens rea. It is all in a fit of anger or emotion. In this case, the investigator has seized the notebook written by the deceased and so called suicide note. Suicide note says you have not considered the impact of your broadcast. A home and family has been broken. You had simply contacted this one.
This is Akashito.
Akashito. And this has been the law with regard to this.
Let him cooperate.
My lord.
Let him cooperate.
Let him go, but my only submission was that they have done something which was not in her knowledge. So when she came to know that they are involved in such business, she, my lord, might be out of fear, she committed suicide.
Right. But
and my lord, section, my lord, 108 of IPC lordship is abator defined. My lord, a person abets an offense who abets either the commission of an offense or the commission of an act which would be an offense if committed by a person capable by law of committing an offense with the same intention or knowledge as that of the abator. That means they have been doing something which was illegal,
no,
but it was.
But you have to show something to bring, to show that the abator, the petitioner intended that the victim should commit suicide.
That is under investigation, Lord. My lord, today is only, my lord, they were arrested on 31/10, Lord. Today is only 20 days, Lord. But investigation is still going on, Lord. Anyway, Lord, I leave it to you, Lord.
How Mr. A.K. Bhuyan, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rajen Sidhana, alias Ranjan Sidhana, alias Ranjan, who has been detained behind the bar since 31/10/2023 in connection with Chandmari Police Station case number 353/2023 under section 306 of the Indian Penal Code. It is the gist of accusation in this case is that on 16/9/2000 and on 24/9/2023, one Srimati Shipra Sarkar, SI of police, lodged an FIR before officer in charge of Chandmari Police Station, inter alia alleging that that one that the victim that one what is the name of the victim?
Yes, that is there in the affair. This is Tangsi K. Shangma, 24 years.
That one Tangsi K. Sangma committed suicide on 16/9/2023 at about 6:30, 5:10 at about 5:10 p.m. by jumping from the roof of flat which was situated at the 6th floor of an apartment known as Subansiri apartment, which belongs to one Mahendra Chand. It is also stated in the FIR that said Tangsi K. Sangma was employed in Medicare call center as a service representative, and said call center was involved in a cyber PS in a cyber crime in cyber PS case number 8/2023 under section 120/490/425/385/471/468/507 IPC read with section 65/66/66B/66D and 66C of the Information Technology Act of the Where is the allegation that you instigate in the FIR?
Yes, that's the last portion of the affair, my lord. 6th floor situated near government, so and so, in the name of main accused of the case, Mahendra Chand. The deceased, fifth line from the bottom, my lord. That is, deceased Tanshi K. Shangma was working in the sales serving at the instigation of the above two accused person to gain more profit by thinking the sales placement as legal. Although deceased was engaged in the same institution and knowing about the arrest of so and so, business of Mahendra Chand, and under apprehension of arrest in the instant case, and also under apprehension of lose her reputation, she committed suicide.
The allegation is that at the instigation of the petitioner, you were working in the, say, instigation of gaining more profit. There is no allegation of instigation
There is no allegation of instigation.
of committing suicide.
No.
It is also alleged in the FIR that the deceased was working in the said Medicare call center at the instigation of the present petitioner and one another co-accused named in the FIR. In order to make more profit and thinking that the work she has been engaged in is legal. However, when the deceased came to know about the arrest of the present petitioner in a cyber fraud case, she apprehended that she may also be arrested. She may also be arrested in the said case, and also apprehended that her reputation would be lost, and hence she committed suicide. Stop. Learned counsel for the petitioner submits that there is no allegation of aid or instigation on the part of the present petitioner in the FIR. It is further submitted by the learned counsel for the petitioner that petitioner was that the deceased Tangchi K. Sangma committed suicide on 16th of September at about 5:10 p.m. Whereas the present petitioner was detained behind the bar in connection with which case?
Cyber PS case number 8 of 2023.
Cyber PS case number 8 of 2002. 23 at that time. When you were
from 15/9/2023 at 7:30 p.m.
He was arrested in the said case on 15/9/2023 at
7:30 p.m.
7:30 p.m. It is also submitted by learned counsel for the petitioner that though the present FIR has been lodged by a police officer, however, the fact of the detention of the present petitioner in connection with the cyber case number 8 of 2023, when the offense alleged in the FIR was committed, has not been mentioned in the FIR in violation of the guidelines of the Supreme Court of the Honorable Apex Court in Uday Chand and other versus Sheikh Mohammed Abdullah, Chief Minister of JK and another, reported in 1983 2 HCC 417. It is further submitted by the petitioner that what is any other submission?
Nothing like that.
It is further submitted by the petitioner that the petitioner is ready to cooperate in the investigation if he is released. On the other hand, learned additional public prosecutor has produced the case diary of Chanmari Police Station case number 353/2023 and has submitted that the petitioner had engaged the deceased to work in the which call center? This is a Medicare call center and which was involved in cyber scam without the knowledge of the said deceased. It is further submitted by learned counsel, learned additional public prosecutor that the investigation of the case is at initial stage and the petitioner has been detained behind the bar only for last 20
Last
days,
21 days.
on 21 days on, and on that ground he has opposed the grant of bail to the present petition. I have considered the submissions made by learned counsel for both sides and have gone through the materials placed before this court, including the case diary of Janmari PS case number 353/23. On perusal of the case diary, it appears that on the day when the deceased so deceased Tangchi K. Sangma had committed suicide. The present petitioner was detained behind the bar in connection with cyber PS case number 8/20. It also appears from record that apart from the allegations made in the FIR and suspicion that the petitioner might have abetted and aided in commission of suicide by the deceased. At this stage of the investigation, there is no material to suggest that there was any aid or instigation by the present petitioner in commission of the suicide by the deceased Tangchi K. Sangma. In view of above, further custodial detention of the present petitioner is not justified for continuing the investigation for sake of investigation regarding the allegations labeled against the present petitioner in the FIR lodged by the SI Shipra Sarkar. Stop. Therefore, the present petitioner is hereby directed to released on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kamrup Metro with following conditions: that the petitioner shall cooperate in the investigation and shall appear before the investigating officer as and when so required for the sake of fair investigation. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the investigating officer. With above observation, this bail application is hereby disposed of. Send back the case. In bail, next item.
Next item, my lord, one thing will change, same thing, name, address, my lord, and the date of arrest is 17/9.
Everything will remain.
17/9, he was arrested, my lord.
So you were not.
No, not in custody.
So there will be something.
Yeah. That will be the changes.
Same auto Marigo, I will change, make necessary change. Same condition.
Same condition. Deeply applied.
Mita, this will require some changes which I will dictate in chapter.
Deeply.
May I please, Your Lordship? City was called for my lord.
The case diary not received, Lordship, in this case.
My lord, since May, my lord, the case is pending, my lord. I am on interim, my
302.
302, my
You have to produce the case. You are interim.
my lord interim.
When can you produce the case?
My lord, this is from my lord.
Heard Mr. F. A. Loskar, the counsel for the petitioner.
28, Lordship. 28/11.
Also heard Mr. R. J. Borwa, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this matter be decided on 28/11 for case.
My lord, 25/30 submitted.
FSF report was called for.
I am sorry, Lordship. FR submitted.
Apart.
FR.
Okay. Miss, what is your name?
Rahul also.
What is the name?
Art.
Miss R. Saha, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, the investigating officer has has submitted the final report bearing number
339/2023, dated 31/11/2023.
in view of submission of the final report. This anticipatory bail application has become infructuous and accordingly.
In both the cases, we have not received the case diary. If we are in interim till receipt of the case diary.
Okay. In both the cases. Heard Mr. M. H. Chaudhary.
MK,
What is your name?
MK Chaudhary. Manjur K. Chaudhary.
Heard Mr. M. K. Chaudhary. In 26, you are there, no?
Yes,
Okay.
sir.
Heard Mr. M. K. Chaudhary, learned counsel for the petitioner. Also heard Mr. R. J. Borwa, learned additional public prosecutor, who submits that the case diary which was called for has not been received and prays for another day for producing the case diary. The prayer is now. Let this trip set.
4/12.
4/12. The interim order shall continue.
It was already till receipt of case diary. Interim.
Okay, till next date.
Okay.
Case diary has arrived.
Case diary not received.
None appears for the petitioner on call. An additional public prosecutor has submitted that case diary was called for has not arrived and prays for another date for producing the same. Prayer is allowed. Let this case be listed again on
30/11.
30/11 for case diary.
The 29 case diary not received.
Third, Miss
P. Bora.
E. Bora, learned counsel for the petitioner. Also at Mr. R. J. Borwa, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on.
My lord, 612
On 8 May.
812.
On
812.
8/12. The interim order shall continue till next day.
Two cases are involved in this particular case, cross case, FIR and a cross case. Now, on the previous date, both the case there is were called for. So I have learned from the learned APP, one case there is not yet received.
Other cross case is not received. So we have received the consent case.
Otherwise, the petitioner is.
417, 439, 493.
I also filed one objection regarding.
What was the cross case under what provision?
Cross case is under section 384.
Extortion. That you have filed.
And my mother is.
And you have filed your wife.
Yeah.
No,
Not wife, Lord.
Not
They were
wife.
in relation. They were in relation.
They were in living, and there are some pregnancy reports.
It is already there in the report.
No. Okay. No, on what ground you are objecting?
I'm objecting for rejection of the case.
No, why are you objecting?
Because he has
His statement has been recorded.
Yes, he has appeared statement recorded.
He has appeared. He is cooperating in investigation. Whether is he threatening you?
cooperating, yes, not, but I am objecting that he has committed a serious offense against me.
Let
against
him
my
face
person,
trial.
against my body, against my person, and my life has been ruined by this. So I am aggrieved. My humble submission before this honorable court that his bail petition, at least executive bail petition may not be considered because heinous crime he has committed. I have all the medical reports. Several times I am pregnant only because of him. Thereafter he cheated me. He never married me, and now what happened? His mother he filed a case against me, alleging that I am for extortion of money. I have committed this. Not to this a pregnancy report for a girl. Why for extortion?
No, we are not deciding the case. We only want to know that after filing of the FIR,
yes,
have he threatened you?
Yes.
Has he threatened you?
Not to kindly peruse my objection. Page number 38. Paragraph that the accused person after filing the FIR against the present bail applicant regularly threatening the victim lady to withdraw the said FIR. Otherwise, he has to face dire consequences in future. Finding no other way, the information no other way except filing the objection petition so that the
when have you went regularly means when? Have you given any? He's not. You are not staying with her now.
No, I'm not.
Where the victim is staying?
No, lots of things that staying in a different
He
accommodation.
is spending a very panic situation
Lots
because
of,
the
I may be allowed to submit as well.
Now, where she is staying?
He can.
No, we will impose conditions so that he may not threaten.
Yes, yes. Lots of things. We are not denying the relationship. He is staying in a different accommodation.
Where?
In Bongaigaon, Bongaigaon town.
Where are you staying in?
I'm in. I stay in Obhayapuri. I work in Obhayapuri. I'm a government servant. And
that means to give threatening, you have to either how he has to threaten you.
He is using muscle power, money power. He's a
No, general statement. General statement would not help. You have to be specific when he went to you.
And also one interesting point at page number 46 or their objection, they have filed one case under section 107. I'm not even party in that case. Page 46. So their allegation of threatening the informant doesn't hold good.
What is the progress in the investigation?
Investigation sufficiently progress
Roti may kindly produce 48, page number 48 of my objection petition. Specific date is there. On 2/9/2023 at about 8:30 p.m., the first party, that means the petitioner of his bail application, went to Abhayapuri market, and when he was shopping at Devdaru stationery near Abhayapuri cinema hall, then the first party found that the opposite parties are standing in the opposite roadside of the shop, of the state. When the first party come out from the shop waiting for an e-rickshaw, suddenly the opposite parties came near the first party and rebuked her with filthy and slang languages and told her to withdraw the Abhayapuri PSF number 61/2023 and detain her by telling that they have enough men and money power, and even they have power to purchase the investigation officer of the aforesaid PS case. And they,
What is your response?
The Lordship,
while shopping, a victim lady while she is in market, they are pretending to withdraw. And as a government servant, he has enough money, Lordship, and I'm a victim lady, helpless lady, no income. I have no income, Lordship. This person is doing such things. I'm leaving up to your Lord.
Lordship, I have already submitted this petition.
2/9, that means prior to your release on grant of
Yes,
entry.
and even after that, he is doing, but no specific evidence we have.
Yes, Mr. Burma, what is your topic?
My humble submission, my lord, that although accusers appeared, but some more investigations are yet to be completed. Medical reports are yet to be collected. Although victim has stated that he undergone, my lord, abortion.
All
Forceful
medical
abortion
reports are
by
here.
and it takes 497, Lord. Oh, sorry, 493, Lord.
Otherwise, the petitioner has cooperated in the
Yes, here's the appear statement recorded.
regarding the submission made by the counsel for the informant that
My lord, there is no such, my lord, entry in the, my lord, case diary.
case diary.
That is,
But how it may be ensured that he does not,
my lord, then again, my lord, the police has to, my lord, investigating officer has to, my lord, examine the victim. Lord.
Regarding this part, regarding detaining.
no, that threatening was prior to his granting of anticipatory bail.
And this,
Even after the granting of the
that statement is not there.
regarding that part, investigation ought to have been carried
Now, what I'm submitting, Lord,
on any ground not to be released in
what I'm submitting, Lord, I have been granted the
When he last threatened you on 2/9,
after getting the anticipatory bail.
when, on which date,
After getting the interim.
which date?
Date is specifically not mentioned.
Where is the statement that after getting he threatened you? In your objection petition,
In paragraph number 3, page number 38, regularly threatening means continuous process. The threatening of continuous.
when
No
he,
specific date I have mentioned.
okay, we take care. Heard Mr. D. Das, learned counsel for the petitioner. Otherwise, Mr. Borua, what is your requirement? He has to appear before the IO.
So he will prepare to the IO and he will, my lord, he will not, my lord, pretend to be, my lord, at least victim girl.
Now, how to ensure compliance?
Sometimes also the victim girl or further investigation or
If there is a complaint against you, and Bail would be rejected, cancelled.
They may approach for rejection of my privilege of it. That condition may be, it may not be made automatically.
Some strict conditions may be imposed. We never, my lord.
These are
Witnesses
concocted allegations. There is no such threatening. In fact, the police, the case filed by the mother of the petitioner, it was registered prior to the registering of this particular case. That investigation is not progressed till today. We are approaching the IO, but IO is not taking our statement. In fact, the petitioner and his family is the actual victim of the case. It may not be seen from the victim side, all girls victims at all in this case.
Okay, I'll go through it
Apply.
and dictate the order at 2.
Obliged, Lordship. And my humble submission before his honorable Lordship, at least this pregnancy and medical reports.
But this is
That he is not denying.
no, Lordship, pregnancy I am denying. This is not at all pregnancy. Lordship will go to the medical.
Yes, Lordship, he is denying. That's why I am again and again showing these documents, Lordship. These are original documents. Pregnancy is now he is denying the pregnancy.
Where is
The Lordship may, for a moment, Lordship is 42. There is no last impression, Lordship. There is a observation regarding particular cyst. This is a gynecological disease. There is no mention of pregnancy. I have consulted, the petitioner has consulted with the medical expert also. It's a radiologist. There is no, and it is a medical report of 2017, Lordship. And she is making the complaint in 2023.
Where is the pregnancy report? Read out.
It is not at all pregnancy. Page 42, last part, Lordship, impression. That is the impression of the radiologist. And that also under question.
Lordship may peruse.
At 2 I will pass.
Comments on record. After getting the interim order, see the informant called up a common friend of the petitioner and the informant, Funny Nadifer. Let's see one to settle the issue mutually. So if she wanted to meet the petitioner in certain location, but that apprehending that it might be a trap for implicating the petitioner in another proceeding, Lordship. The accused refused to go there and proposed to meet the informant in the police station. But thereafter, there was no call. So, if the condition of cancelling the bail privilege of the petitioner is imposed, the informant might come up with certain traps to implicate the petitioner in every other day. The complaint that they have alleged to have made, it is not made before the police station. It was made before the magistrate. And on the top of that, the petitioner is not even the party in the proceeding. And on my instruction, Lordship, it is that no such incident happened. That they was alleging that on 2 nights of incident, but no such incident. In fact, Lordship, I have brought one FIR in my petition, Lordship, at page 25. After
yes.
At page 25, the informant became so desperate that she moved from Bongaigaon to Martia, Lordship. It is a location which might be 150 or 200 kilometers from Bongaigaon. It's a Gwalpar district. She threatened the elder sister of the petitioner in search of the petitioner in the morning at 4 a.m. Lordship, in the presence of her husband and minor son, Lordship. That case is also registered against the informant, Lordship. And Lordship, on the of the record, Lordship, on the moving the case for the motion hearing on 15/9, Lordship, she tried to reach me through social media also. She tried to influence me also. She was keeping the track of the petitioner everywhere, wherever he is going, who is the advocate concerned. There is I have all the screenshots of her. On the day of motion hearing, I produced everything before the.
No, otherwise, Mr. Purva, otherwise the petitioner is cooperating in the investigation. He has appeared before the IO, made his statement. Only apprehension is that he should not threaten the informant and other. That protection. That protection would do. Heard Mr. B. Das, learned counsel for the petitioner, also heard Mr. R. J. Barua, learned additional public prosecutor, as well as Mr. G. Samoa. What is your name? G. Samoa and J. A. Ahmed, learned counsel for the informant. Learned counsel for the petitioner has submitted that the petitioner who was having a love relationship between with the first informant for about 7 years of time, for 7 years, has been wrongly implicated in the FIR lodged by the victim. It is further submitted by the learned counsel for the petitioner that by order dated 15/9/2023, the petitioner was allowed to go on interim anticipatory bail by this court with certain conditions. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer of the Abhayapuri PS case number 361/2023 and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of the investigating case diary of the Abhayapuri PS case number 361/2023, which was called for in connection with this case, and has submitted that the petitioner has appeared before the investigating officer, and his statement has also been recorded by the investigating officer. Mr. G. Samoa, who was there in the first half? Mr. Samoa?
He was there.
Mr. G. Samoa, learned counsel for the petitioner, has learned counsel for the informant, on the other hand, has vehemently opposed the making of the interim anticipatory bail absolute at this stage on the ground that there are serious implicating materials. The petitioner, the allegations leveled against the petitioner are serious in nature, and the petitioner has also been regularly threatening the informant/victim to withdraw the FIR. It is further submitted by learned counsel for the informant that on 2/9/2023, the petitioner had
The allegation is not against the petitioner. In the record, in the annex documents.
who is the first
The other family members, Thoriti Das, Utpal
the
Das,
family members of the petitioners have threatened the first informant to withdraw the case against the present petitioner. Now, I have considered the submissions made by learned counsel for both the sides and have perused the materials in the case diary, including the statement of the victim as well as medical reports annexed therein. It appears from the record that though the learned counsel for the petitioner has alleged that the petitioner, learned counsel for the informant has alleged that the petitioner has been regularly threatening the victim to withdraw the FIR. However, no specific dates has been mentioned in the written objection on which the such threatening was such on which such threatening has been made by the petitioner. The specific date on mentioned in the objection petition is of 2nd of September, on which the allegations are not against the petitioner but against his family members. It also appears that the petitioner has appeared before the investigating officer and has cooperated in the investigation. Now, there may be some materials, there may be truth in the allegations leveled against the present petitioner by the informant. However, considering the fact that the petitioner has been cooperating in the investigation since he was allowed to go on interim anticipatory bail, his custodial detention for the sake of fair completion of the investigation does not appear to be necessary. Hence, interim anticipatory bail granted to the present petitioner by order dated 15/9/2023 is hereby made absolute, with condition number 2 and 3 attached to the said order remaining intact, as well as following condition and following added condition is added thereto. The petitioner shall appear before the investigating officer. Where do you stay?
I will stay in Abhayapur.
Case is pending in Abhayapur. Petitioner shall appear before the investigating officer of the Abhayapur PS case number 361/2023 every week for next 4 weeks, or till the investigation is over, whichever is earlier, and shall cooperate in the investigation. And he shall not in any manner make any inducement, threat, or promise to the victim girl or to any other person/witnesses who may be acquainted with the facts of the case, so as to dissuade such person/persons from disclosing such facts before the investigating officer. With above observation, this anticipatory bail application is hereby disposed. Send back the case.
Production list item number 1.
Heard Mr. T.K. Bhuya, learned counsel for the petitioner. Also heard Mr. M. Aloy, learned special public prosecutor, CBI. Let this case be listed for delivery of orders on 22/11/2023, day after tomorrow.
Item number 2.
Same one. Lawyer's name would be different.
I appeal for T.K. Bhuya.
Okay. What is your name?
S. Bodhakumar.
S. Bodhakumar. Instead of T.K. Bhuya, S. Bodhakumar. On 22/11.
Yes.
এতিয়া কি কৰিব? Now, after this. Yes.
For that, that is just 40.
There is a bar.
Yeah.
Yeah.
No successor not but it
Case of?
It was my case of failure. His case by his was not done. So he paid for payroll. They can get payroll. Paragraph 59 is happened. Case number 466. 2008. 437.
Yes.
Paragraph 29. Under the circumstances, the pixels are disposed of by Hosticare. Section 38 does not in any way affect the powers of the authority transferred. That has been clear. Now, number 2, it is unconstitutional. The extent it takes away the right of the court to suspend the sentence of a convict under the Act. And number 3, this is important. Nevertheless, the sentence awarded under the Act can be suspended by the executive only and if the subject to the constitutional spelled out in section 37 of the Act as stated in this. Now, just another paying for suspense position. That's what section 38 the education is not verified. Now, in this case, what the said, suspense of can be considered or permitted, but course of section 37
Would be applicable.
Section minor, now minor, paragraph 30. It's my instruction number going for then is divided to apply for payroll. So this payroll was true. That's why here final suspended. That is the minor.
No, they have cited this judgment only to show that the bar of 32A has been declared as unconstitutional.
But it can be minor considered, but at the same time,
rigors of 37 has to be considered. So that bar is not there. 32A bar is not there now. But we have to see whether they can jump over 37 or not. Now, whether we can see these things at this stage or when, that is my question to the appellant. That whether at the stage of 439, 389, we can go in depth and see whether 37 bar would be applicable or not. Then it would amount to, we can go through these pleas raised by you only in the full hearing. Whether at this stage, that was my query. Yes, Mr. Burma. These are two. Yes.
After the order of justice, there should be something apparent or lost on the face of the record. On the court can arrive at a private decision that the conviction may not sustainable. The appearer, the part of the court, therefore, see whether the case presented by and accepted by the trial court can take a case with ultimately the conflict sense for fair counsel. Apparent to the Federal party. The appearance court should not give the evidence at the stage of section 18 of the chapter and try to pick up few lacunas or both here and there in the case. Thus, not be correct. I'm referring to paragraph 32.
Yes.
They have also referred 100% of 2009, 830, 530. They are referring to paragraph 35 and also referring to paragraph 35. Upload this.
Which judgment?
2009, 8.
Colonel Singh.
They are referring to paragraph 35.
Yes.
Paragraph 37 says 554. So it was paragraph 35 upload this. So this was this was recovered in a France. It was a France recovery. So they were in a Naka section and they with their vehicles are they recovered this. Yeah, it is. It's a 35 upload. The was on the but by the book matter so the peak of either by mobile phone or the information call for get he delay that the data good for experience big move for not for take down in 90 information take action by both A to B of 41. Thereafter, the technical for the night outfit of the set of the it is an effective care done so after the recovery for the trans recovery so for the regular data technique especially that is contravention was recovered. He has made all the professional other day and he might not put how they have said but there was no private.
Yes.
For that reason, to answer that, we will have to go by the PW1.
Now at this stage, 389, whether we'll go in depth.
Because, Lordship, to dispose of the bill application, definitely, at least to some extent, this honorable court, in my humble submission, must go. Otherwise, what will be the basis whether the appellant is to be granted bail or not? To decide, to come into a conclusion, definitely, this honorable court must enter into the merit to dispose of this case. Now, for that reason, at least PWs are to be considered.
Where is para 33 of Om Prakash? You have that judgment?
Lordship, what he has referred?
Yes.
No, I have not. Live. Lordship, here, para 33, bearing in mind, this only one sentence I will be reading. Bearing in mind the aforesaid principle of law, the endeavor on part of the court therefore should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chances of acquittal. So this is what to be considered while disposing this type of petition, probably, what I have understood. Now, to answer this, if we rely the 40, what learned friend has submitted, in our case, there is a total non-compliance of section 42. And for that reason, we have relied the 5-judge bench. So we have relied that Colonel Singh's judgment, where if we go by that paragraph, if we go by the paragraph 35, clause small d, if we go by clause D at page number 555, while total non-compliance with requirements of subsections 1 and 2 of section 42 is impermissible. Delayed compliance with satisfactory explanation about the delay will be acceptable compliance with section 42. Now, in this case, neither that information was entered in the GD, nor it was sent forthwith, nor in a delayed period it was ever sent to the superior as the mandate of 42. That is not coming out of the evidence that it was ever made, even though it delayed. So it is a total non-compliance case, not forthwith, nor in a delayed period. It was ever informed. What appears from the record of the case. And from PW1 itself, evidence, it is apparent that information has been received by PW6 and accordingly they proceeded. So PW1, but if we go by the PW1 in our petition,
At which page you have?
Lordship, it is page 68 itself. Page 68 of our petition. It is the deposition of PW1, who is a police personnel. His name is Gopi Rabha. In the 1, 2, 3, 4, 5, 6th line of his deposition, he has stated at that time the informant, that is PW6, received the information over phone. It is very much clear from the evidence of
page.
Yes, Lordship, it is page 68.
68 is not there.
Oh, in the IA, Lordship.
Yes.
Lordship, it is the 1, 2, 3, 4, 5, 6 sentence. It is the PW1 who is a police personnel. He categorically has deposed. At that time, the informant, that is PW6, received information over phone that a Maruti Alto vehicle bearing registration number so and so carrying drugs will be approaching so and so. So it is apparent from this prosecution itself, witness itself, that information has been received over phone by the PW6, who is happens to be the informant. Now, whether record says that he has forthwith informed to his superior as
what PW6 has stated.
PW6 is denying, but this is also prosecution why this witness has to be disbelieved, because PW6 definitely will say that he has not having any prior information. But what about this PW1? So it will remain, it is their witness. He has not been made hostile, putting any other question to this effect. Now this fact will remain.
Whether PW6 was asked this question during cross-examination, that whether you have received information over it.
PW6.
Page 81. Page 81, the first paragraph.
81. He has stated, I did not have any previous information that were being transported. He has said so.
Now the question is whom to rely, whether PW1 or PW6.
But whichever goes in my favor, that is the correct proposition of law.
But at this stage of 389, whether we can take that decision that PW1 is more reliable, PW6 is not. Okay.
That is, brother, both are prosecution witness, and this is he volunteers to say in the examination in chief itself. This PW1 being a police personnel. So there is no reason in my humble submission to disbelieve that PW1 and PW6 being the informant of this case, he is definitely a interested witness so that he can establish his case. He may say anything, but he is also PW1 is also a police personnel, and to that effect, he independently and voluntarily he has stated in his examination in chief itself. So for that reason, in my humble submission, this Lordship may consider PW1 and
At what stage the main appeal is pending?
it
is fixed for hearing.
LCR has some.
Okay. In main appeal, heard Mr.
B.
Bhagavati, learned counsel for the appellant, also heard Mr. R. J. Barua, learned additional public prosecutor. The LCR has been received. I say no. LCR has been received. Let this case be listed for hearing in its usual course. In interlocutory application, day after tomorrow.
Yeah.
Heard Mr. B. Bhagavati, learned counsel for the petitioner, also heard Mr. R. J. Barua, learned additional public prosecutor. List this case for delivery of orders tomorrow.
Tomorrow
in 21 on 21.
Highly obliged.
Itu bench to information listing of list like by sleep. So let it, lawyer would be necessary. Let the counsel come. None appears for the petitioner on call. Learned Mr. R. J. Barua, learned counsel for the learned additional public prosecutor is present on behalf of respondent number 1. Let this matter be listed again on 24/11. 24/11.
Item number 31.
In this case, earlier case diary was for. Otherwise, my lord, the main accused in this case has already released on bail also, and the present accused petitioners are the parents and brothers of the main accused.
You are on interim?
No, my lord, no interim protection. So, may I kindly pray for?
But whether any apprehension is there still?
Yes, lord. And the accused petitioner number 4 is a 53-year-old lady.
Heard Mr. M. Zaman,
Raman.
learned counsel for the petitioner. Also heard Mr. R. J. Barua, learned additional public prosecutor, who submits that though the case diary was an updated case diary was called for, however, same has not been received. It is also submitted by learned counsel for the petitioner, learned additional public prosecutor, that on earlier occasion the case diary was received, however, same was not updated, and therefore same has been sent for updation. Let them appear. What is the allegation?
My lord, the present accused petitioner are the parents and brothers, my lord. The main accused number 1 of the FIR, my lord, Jahedul, he was already on released on bail. My lord.
Where is the FIR?
FIR at page number 8, lord.
Against whom the allegation is there?
My lord, allegations are not specific, my lord. Therefore, the persons on that day,
They are all FIR.
their name is
Case diary would be required.
short date, my lord. May I play for 20 on 24th, my lord.
What was Though several dates have been granted to the prosecution side for producing the case diary, however, it also appears that considering the nature of allegations level in the FIR, the perusal of the case diary would be necessary for consideration of the instant bail, anticipatory bail application. Hence, the prosecution side hence learned additional public prosecutor shall ensure the production of the case diary on the next date fixed.
Can it be on 24th, lord? So no protection.
Let it be on 28. Let this case be listed again on 28/11 for case diary.
Obliged.
Very close. In this case, what your lordship initially rejected, and your lordship order is page 17. Subsequently, by the second time, your lordship was pleased to give interim order page number 2, considering his age and his ailment. Oh, sorry, 1, Abdul Jalil. And the injury report, as your lordship also observed in the second order dated 18/10/23. Initially, might have referred to medical college, but that report was not there. Subsequently, might have to my information report is there, but a simple injury, I plan to refer. So, 26 is not coming, 7 is not coming. That is our case.
Injury report is there. Nature of injury?
Course below the order is there, Mario. Kindly see my observation. Page 19. Page 19. Yeah. You appeared, man. Now, page 19, you look at this page 19, considering matter bottom. Consider the same, it appears that the ingredients on a prior to that matter, prior to last paragraph, it reveals that he was medically examined on 15/6/20 at about 9:41 a.m. and that the concerned senior medical health officer found that the victim was having a simple injury caused by blunt object. Considering the same, it appears that the engagement of section 326 is not attractive by the procedure criteria also the
Gwa- Gwalpara Civil Hospital's
Yeah.
doctor's
Initial.
injury report is there.
Yeah. ठीक है sir.
So no, keep it with yourself. So prima facie, there is a material to show that initially the injury found was simple injury. Then he was referred for better medical treatment. Grievous or not, that is awaited. So what is your submission?
If 326 is not there, 327 the other available. Other sections are available, man. No other section, only 326 and 327. And one already arrested in that order, this order was passed. On the spot, one person was arrested.
No, but once this court has rejected your
But that the funding was not there. Maybe because it was referred to medical college. That is there. Page 18.
now also we don't have the finding.
This is there. But that was reflected in the court below the order.
So we have to either wait for the report of the, we may make the interim
think-
anticipatory bail to the petitioner number 1 absolute, or and reject the second.
Oh my.
But that option I am giving.
Yes. That
Or
come as early as possible, man. The program.
or we may wait for the.
Or I
Or
prefer.
you are preferring or.
If Golpaka comes, that will do, madam. If Golpaka comes, that will do. That
Okay.
also lordship mentioned.
But the anticipatory bail of petitioner number 1.
No, that is his involvement is not there.
It may be made absolute.
But nothing,
Okay.
he said nothing
Heard
is there.
Mr. H.R.H. Chaudhary, learned senior counsel, assisted by H. Ali, learned counsel for the petitioner. Also heard Mr. R.J. Borwa, learned additional public prosecutor. Learned counsel for the learned senior counsel for the petitioner has submitted that on by order dated 18/10/2023, the petitioner number 1 was granted interim anticipatory bail, and in pursuant to the said direction, he has appeared before the investigating officer and has cooperated in the investigation. Learned senior counsel has also submitted that earlier in the month of July, that is on 20 July 2023, the previous anticipatory bail, the anticipatory bail application filed by the petitioner number 2 on previous occasion was rejected by this court on the ground that there were incriminating material against the present petitioner, and the injury report from Guwahati Medical College Hospital was not received.
It should be Golpara, not Guwahati Medical College.
Gwalpara Medical
It should be
College.
Golpara Medical.
Gwalpara Civil Hospital.
Golpara Civil Hospital.
Gwalpara Civil Hospital is not received. Learned counsel for the learned additional public prosecutor has On the other hand, produce the case diary of the Fakirganj PS case number 106/23 and has submitted that considering the fact that the victim has sustained injuries, the medical report of the victim from Gwalpara Civil Hospital or Medical College.
No.
Gwalpara Civil Hospital would be necessary for consideration of the instant anticipatory bail application. Hence, call for the injury report. Fixing.
That is too late, madam, because 1 year lordship is not giving, I think. It is not true.
No, but that has to come.
That has to come. For that, my lord, 2 is not required, madam. I think cities here only they have to send the report, madam. Today is 28.
When can you bring?
28.
Let this case be listed again on 30th of. Because there is an observation against you in the initial earlier bail order.
That's right.
So unless report is
That's
favorable, you may.
That I understand. The interim order took
In the meanwhile, interim order in respect of
petitioner
number 1 shall continue till next.
My lord, I have a prayer, my lord, your lordship, my junior mentioned one case item 62, and if somebody is trying to go for some urgent matter, fine. So item 62 take only 2 minutes, but only admission matter. 62, man.
It has to be admitted.
Only admitted. I am not pressing for bail also.
Okay.
62. Ayyako. LC has to be called, my lord. Notice to respond number 2 to go, my.
Heard Mr. H.R.A. Chaudhary, learned counsel for the learned senior counsel assisted by Miss R. Deka, learned counsel for the appellant. This appeal has been referred by
Prepared against the judgment of page 2.
This appeal has been filed under section 374 of the Code of Criminal Procedure, 1973 by the appellant Mohibul Islam, impugning the judgment and order dated 7/9/2023 passed by learned additional session judge special judge Boxo Dhubri in special case number 11/2021, whereby the appellant has been convicted under section 376 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 5,000 and in default of payment of fine to undergo simple imprisonment for 6 months. This appeal is admitted for hearing. Issue notice to the respondents as the learned additional public prosecutor has appeared for the respondent number 1. No formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the appellant shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from date of this order, returnable after 4 weeks.
Call for the LCR.
Also call for the LCR registry to take steps for requisitioning the LCR.
IA minor may be considered on the receipt of the records. Bail.
In IA, heard Mr. H.R.A. Chaudhary, learned counsel for H.R.A. Chaudhary, learned senior counsel, assisted by Ms. R. Deka, learned counsel for the applicant / appellant. This application has been filed under section 389 of the Code of Criminal Procedure, 1973, for suspension of sentence imposed on the present applicant / appellant by the judgment and order dated 7/9/2023, which has been impugned by the present applicant in connected criminal appeal number 396/2023. Stop. The LCR has already been called for in the connected appeal. The present interlocutory application shall be considered after receipt of the LCR. Issue notice to the respondents. Since issue notice to the respondents, since
one notice will do on appeal, they will.
you mentioned in that notice it is for, since respondent number 1 is being represented by an additional public prosecutor, no formal notice need to be issued. As regards respondent number 2 is concerned, the applicant shall take steps for issuance of notice by registered post with AD within 3 days from date of this order, returnable after 3 weeks.
May I please, Your Lordship? This is a 438 application, Your Lordship, whereby the case is registered under section 313, 304 and 34 of IPC, Your Lordship. This is the fifth day of hearing, Your Lordship, and the CD was called for along with the postmortem report, Your Lordship.
It is not there.
It is not. I have a humble prayer to make, Your Lordship. As Your Lordship, the police has not seized anything while sealing the pharmacy. After the allegation is that, Your Lordship, a woman has been forcefully terminated, who has been subjected to forcefully termination of the pregnancy by her husband with the help of petition number 1 and 2, Your Lordship. That is the allegation, Your Lordship. The FIR is on page number 10, Your Lordship. Annexure number 2, Your Lordship.
No, but there is an observation by this court that perusal of the case diary would be necessary.
Yeah, it is necessary in order to know whether the pregnancy was terminated surgically or by medicines or induced due to any physical injuries. We agree to that, Your Lordship. But Your Lordship, since the I have not been protected, I'm not on interim bail, Your Lordship. Can I press for it, Your Lordship? Because one of the petitioner is a woman, Your Lordship. And before praying before Your Lordship since September 2023. Your Lordship. So kindly, I may be protected, and the public prosecutor may take time as much as they want to produce the post-mortem report, Your Lordship. Kindly, Your Lordship. At least I may be protected, Your Lordship. I have before the honorable
We are
court several
protecting
times.
the woman.
Yes, Your Lordship. That will do, Your Lordship.
Let the petition number 2, who is woman, heard Ms.
P. Das, Your
P.
Lordship.
Das, learned counsel for the petitioner, also heard Mr. R.J. Barua, learned additional,
Yes, Your Lordship. The husband and wife.
learned it. If wife goes to you, you will be in a better position to apprehend the husband.
Yes, will appear, Your Lordship.
Heard learned additional public prosecutor who submits that though the case diary was called for, however, same has not arrived, and prays for another date for producing the same. The prayer is allowed. On the other hand, learned counsel for the petitioner submits that today is the fifth day for fixed for producing the case diary. However, the case diary has not arrived, and petitioner number 2, who is a woman, may at least, and it is submitted that at least petitioner number 2, who is a woman, may be protected in the meanwhile. Considering the submissions made by learned counsel for the petitioner, the petitioner number 2, namely Musammat Asmina Khatun, is hereby directed to appear before the investigating officer of Boko PS case number 426/23 and cooperate in investigation within 10 days from date of this order. If she does so within the stipulated period of time, she shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to satisfaction of the arresting authority. The additional public prosecutor shall ensure production of the case diary on the next date fixed. Let this case be
After 10, so मैंने 4/12 को after 10 or before 3, any date after any date.
11/12.
Deeply objection.
May I please, Your Lordship? Well, in this case, the petitioner is protected and he appeared before the IO. But his statement has been recorded. So, like, FIR is at page 7.
Has his statement recorded? Heard Mr. M. Khan, learned counsel for the applicant. Also heard Mr. R.J. Borua, learned additional public prosecutor, who has produced the case diary of Bongaigaon PS case number 387/23 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 CRPC has been recorded and his further custodial interrogation may not be necessary for fair completion of the investigation. Considering the submissions made by learned additional public prosecutor, the interim anticipatory bail granted to the petitioner Dhananjay Das by order dated 9/10/2023 is hereby made absolute. Let the case diary be returned back.
May I please, Your Lordship? It's a for 38 application. The second time the petitioner has filed this application. Your Lordship, the file is at page 30, Your Lordship. And relevant portion is start from 34. The allegation is under section 409 and 420 IPC. And so far, the petitioner has given his statement, recorded his
Statement 2.
IO.
You have appeared before IO.
Yes, sir.
IO has not arrested you.
No, Your Lordship, since 2015, Your
Then why there is no apprehension of being arrested?
Lordship, but
You have appeared before the person who may arrest you. He has not arrested you. There is no apprehension. This
Your Lordship.
anticipatory bail application does not lie.
Your Lordship, still, but the shot will be hanging over his head, Your Lordship. He may be arrested any moment. That's the thing. In 2019, Lordship.
Whether his statement is there.
Was rejected at that point of time, the situation was different. Now, already a statement has been recorded, so I don't think there is any custodial.
No, whether his statement is recorded or not. You go through it.
But last time also, the CD was called for. It has come, and
No, if we again call for the up to date, it will be pending further.
yes.
Okay. heard Mr.
S. Dekar.
S. Dekar, learned counsel for the petitioner. Also heard Ms. S. H. Bora, learned additional public prosecutor, who prays for an adjournment on the ground that she has to take some more instructions from the investigating officer regarding the regarding the fact as to whether the petitioner has appeared before the investigating officer or not. The prayer is allowed. Let this matter be listed on 22nd November. Again,
Obliged.
the case diary shall be retained till then.
For 30 reputation, my lord, on last occasion, my lord, after serious called for. There are three petitioners, my lord. Petition number 3 is on UP, my lord. Yes, my lord.
CD has not arrived.
What should we give, my lord?
Heard Mr. J. Islam, learned counsel for the petitioner. Also heard Ms. S. H. Bora, who prays for another date for producing the case diary. The prayer is allowed. Let this matter be listed again on 8/12. The interim order in respect of the petitioner number 3 shall continue till next date.
May I proceed? In this case, petitioners were granted interim bail, and according to their appeared to die. FIR case 11, allegation under section 3.
Appeared. Heard Mr. S. Alam, learned counsel for the petitioners. Also heard Ms. S. H. Bora, learned additional public prosecutor, who has produced the case diary of Sangsari PS case number 95/2023 and has submitted that the petitioners have appeared before the investigating officer and their statements are also recorded. Stop. As it appears that the petitioners have cooperated in the investigation and has complied with the directions of this court, the interim anticipatory bail granted to them by order dated 10/11/23 is here.
11/10.
11/10/2023 is hereby made absolute, subject to the condition that they shall continue to cooperate in the investigation. Send back the case.
May it please your lordship. This is a 438 application, my lord. We are on interim, my lord. We got interim on 13/10/23, my lord. On 15/10/23, we appeared, my lord.
You are objecting. No, you are for the, I have not.
So he's saying on another case of a co-accused is fixed on another date.
Co-accused. You are for the informant.
Informant. So my case is totally different, man. I am not for the accused number 1, man. So you may kindly see the FIR, man. Page 11. Actually, it may be treated as the second FIR, man. And after we appeared, man, on 15th we appeared. I have specific information. Instruction from my that we have appeared.
Allegation is against
And against, madam, our allegation is that we, my lord, somehow, they instigated the victim girl to depose in favor of the petitioner in an earlier case, my lord. Accused number 2, 3, 4, and 5, my lord. So, my lord, these things may be treated as a part of the that FIR, my lord, because
But otherwise, from the case diary, it is not clear whether they have appeared.
My lord, that is.
the case diary he submitted till 9/10, my lord. And I got interim on 13/10, my lord. We got interim on 13/10.
You seek instruction.
My lord, whether they have appeared or not.
And the another case is fixed on
22 November. That is day after.
day after tomorrow. We will not get the
My lord.
heard Mr. S.M. Abdullah P. Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Prosecutor, as well as Mr. A. Alam, appearing for the informant. Learned Counsel for the petitioner submits that the petitioners were granted interim anticipatory bail by order dated 13/10/2023, and in pursuant to the directions of this court, they have appeared before the investigating officer and have cooperated. However, an additional public prosecutor submits that as the case diary which has been received today is updated only up to 9/10/2023. Hence, it is not clear from the case diary as to whether the petitioners have appeared before the court, before the investigating officer or not, and seeks some more time to obtain up-to-date case diary and necessary instructions from the
As I have an interim, my lord,
investigating.
let it be in the month of December, he may.
Yeah. In the instructions from the investigating officer. Let this case be listed again on December some date.
7th.
December 7th, 2023, for updated case diary.
Along with the statement of the petitioner.
Along with the statement that would be there.
My lord, that will be.
There. The petition, the learned additional public prosecutor may also seek necessary instructions from the IO in the meantime.
Oblige him. Till then, my lord, the interim order.
The interim order shall continue till next.
Oblige.
7th.
May I please read?
Yes.
We have received interim order on 13/10/2023, your lordship, and we have appeared before the investigating officer, and our statements have been recorded, your lord. And the investigating officer visited my residence also.
Yes, Mr. Chair.
My lord, we have received the case similar, my lord. Here is also in the same, my lord. It is up to, my lord, 21/9, my lord.
You seek telephonic instruction.
My lord, my lord. Otherwise, medical report is also available, my lord. I will take instruction, my lord.
What is the medical injury, nature of injury?
Blunt grievous, my lord.
Grievous.
My lord. Blunt grievous, my lord. And material is that, my lord. He is the accused person who has assaulted the my lord informant, my lord.
The FIR is, I would like to refer the FIR, your lordship.
No, we are not disposing it of today. We are calling for an updated case diary.
My lord.
Till then, interim shall continue.
My lord.
Oh, pleasure.
Dr. J.D. Count.
Yes.
Also heard Mr. B. Sharma, learned additional. Heard Dr. J.D. Count, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the case diary which has been received today has been updated only till 21/9/2023. On the other hand, learned counsel for the petitioner submits that the petitioner was granted interim anticipatory bail on 13/10/2023. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. However, considering the fact that the updated case diary is not before the court, let this case be listed again on
11th, my lord. 11/12.
11/12/2023 for an updated case diary.
My lord.
The interim order shall continue till next day.
My lord. Much obliged.
Lordship, 438 application lordship, FIR in page 11. Lordship. I am reading the
My lord, here is also, my lord, we have received a case diary. My lord, after interim, whether he has appeared or not, that is not, my lord. But from the IO note, my lord,
There is no interim order.
no interim. Oh. In my-
Yes.
FIR is page 11. Accused Lordship, unknown persons on two-wheeler number S11X2479. Dear sir, I L an employee of Punjab National Bank, presently posted at PNB Natun Bazar branch manager. I was on my way from office to home when stopping on the way for purchasing some edible. Thereafter, an unknown person who is also staying near the shop starts abusing me in English of cookie rascal being in Lala. As I am aware of what he was saying, I do not respond to his abusing words and abstain from unnecessary argument. Then he came straight to me and asked where I was belonging. Still, I don't respond his question, as he is totally a stranger to me. After paying for what I have buy to the shopkeeper, I left the shop and the unknown person pursued me unto Central Market Point. The unknown person overtake me at the point and blocked my way with his two-wheeler. When he blocked the way, he stopped his vehicle and came towards me and stand in front of my way and started grabbing my shirt. In the scuffle, he picked up a brick and hitting me with it on my head and body. On his attempted, he picked up a brick and hitting me on my head again and with his bleeding. The unknown person fled towards Mirigal. When people gathered and southward police came, the time and incision around 8:20 p.m. of yesterday, 7:27 on 23. I would like to request your kind cooperation and take the day above name. Lordship. Lordship, it was registered under section 341. That is Lordship, punishment for wrong.
Now, why
statement.
are you apprehending your arrest?
Yes, Lordship, my two-wheeler number is given in the. Okay, Lord.
This two-wheeler belongs to you.
My lord, belongs to the petitioner.
So why should he? That means you are involved.
No, Lordship, from the FIR, Lordship, it is clear, it is abuse in English language. I'm hardly know English, Lordship. I'm a daily weather laborer. My son might have used the two-wheeler, Lordship. He usually he rides car and he arrested and subsequently he released on bail. Lordship.
Your son has been
Yes, Lord.
arrested.
Lord.
Okay.
My lord, we have
What-
received the case there, my lord. Here the allegation is that, my lord, he is the employee of the Punjab National Bank, my lord. He has come to the recently, my lord, in this place, my lord. That's why it is unknown to the person, other person also, my lord. Therefore, there is some altercation, my lord. Therefore, assaulted the, my lord, informant, my lord, employee of the Punjab National Bank, my lord. Here we have received the injury report also, my lord. In the injury report, my lord, 3 injuries are there, my lord. But simple and blunt.
When his son was arrested,
Son arrested, my lord, he is the main person involved in
Son.
the. No, my lord, the present petitioner, my lord.
No, from the bearing.
From the statement of the witnesses, my lord, and also eyewitnesses are also there, my lord. From the eyewitnesses, it is found that, my lord, statement of the eyewitnesses. Only one.
heard Mr.
D. Dalal.
Otherwise, statement of witnesses are
My lord, thank you, my lord. Some eyewitnesses are also there. From the eyewitness, it is revealed that he is the, my lord, person who assaulted the, my lord, bank employee, my lord.
heard Mr. Joyanta, heard Mr. R. What is your name?
D. Dalal.
Heard Mr. D. Dole, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Joyanta Singha, who is apprehending his arrest in connection with Lala PS case number 249/23 under section 341/326/295A/307/34 of the Indian Penal Code. The accusation against the present petitioner is that on which date of FIR?
28/9/23.
On 28/9/2023. 1. JTK Siam lodged an FIR before the officer in charge of Lala Police Station, inter alia, alleging that on the date of lodging FIR, when the first informant was going to his home from his office, that is the Punjab National Bank, of which he is the branch manager, he was hurled abusive language by some miscreants who were abusive language by one person who was riding a two-wheeler bearing registration number AS 11X2479. 2479. And he was assaulted by the said person, causing injuries on his person. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR against the present petitioner are not true. It is further, you are submitting that it is your son.
Lord.
You are making that submission.
My duty. Maybe, Lord. Usually he writes my two-wheeler.
It is submitted by learned counsel for the petitioner that usually the son of the petitioner used to ride the two-wheeler motor. Two-wheeler, what is?
Scooty.
Two-wheeler scooty, which is owned by the present petitioner. It is also submitted that by the learned counsel for the petitioner that the son of the petitioner was arrested in connection with this case, and later on he was released on bail. It is further submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that the case diary of Lala PS case number 249/23, which is produced today before the court, shows that the statement of witnesses recorded during the investigation by the investigating officer implicates the present petitioner. However, learned additional public prosecutor also submits that the injury report, which is available in the case diary, shows that the victims sustained 3 injuries which are simple in nature. Stop.
By blunt weapon.
By blunt weapon. Custodial detention would be necessary.
My lord, from the method.
Considering the fact that the investigation has been fairly progressed, and also considering the fact that the injuries sustained by the victim are simple of nature, custodial detention of the present petitioner does not appear to be necessary if he otherwise cooperates in the investigation. Hence, the petitioner S. Jayanto Singha is hereby directed to appear before the investigating officer of Lala PS case number 249/23 within 10 days from the date of this order and cooperate in the investigation. If he does so within a stipulated period of time, in the event of his arrest in connection with Lala PS case number 249/23, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions: that he shall not directly or indirectly make any inducement, threat, or promise to the victim, that rightful condition, that he shall cooperate in the investigation. With above observation, this anticipatory bail application is thereby disposed of. Send back the case.
Deeply.
May I please your lordship? My lord, for 38 bail application, my PD was called for, my lord. FR is page 13.
What is the injury?
My lord, we have received the case diary without injury report, my lord.
Injury report.
I pay for some time, my lord.
Injury report, because for that
My
was
lord.
referred. Heard Mr. N. Islam. M. Islam, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed.
The CD is injury report, only injury report.
Who prays for some, who submits that though the case diary has been received, however, it is without any injury report, which may be required for the consideration of the instant bail application. Hence, prays for some more time for producing the injury report of the victim. The prayer is allowed. Let this matter be listed again on
6th, my lord, 6th of December.
Short date may be given. There is no interim order. My lord, earlier, my lord, initially moved on, my lord, 1910.
But injury report would
My
be
lord, it will depends on injury report, my lord. Everything will be
6/12.
My lord, 6/12, my lord.
Highly obliged, your lord.
Wait, Mr. Lordship. 438 application, Lordship. The FIR case, Lordship, 9, Lordship. The FIR lodged against Lordship one, brother-in-law, husband, father-in-law, mother-in-law. Petitioner here, Lordship, only brother-in-law. There is a family dispute, Lordship. Subsequently, Lordship, informant shown an affidavit, Lordship, that they settle their dispute. Case 14, Lordship.
What is your name?
M. Mondal.
No, the name of the petitioner.
Petition Azirul.
Azirul Sheikh.
Azirul.
Azirul Haq.
At Elias Azirul Sheikh.
But the allegation is against you only.
Yes, 376.
Subsequently, Lordship, they settle, Lordship. Case 15, Lordship. The informant shown affidavit.
How will we know that this is? How 376 may be settled?
Family dispute, Lordship.
Statement is there.
Yes, sir.
Yes.
Made to Lordship, madam. But this is a case coming out of a cost case, my lord, domestic violence case. A lady, my lord, he filed a domestic violence case.
Yes.
Yes, it is humbly stated that on 14/8/23 at about 7 p.m. My sister-in-law Shantimanu, that is petition number 1. Petition number 1. Sister-in-law Shantimanu, that is second wife of my brother Muhammad Ali, called him to her house through phone. After receiving the phone, while my brother was going to the house of her second wife, then 4 to 5 persons restrained him and pulled down his lungi, injuring his private parts which was bleeding. My brother then raised him and cry and took shelter at the house of Fulchan. Thereafter, at about 10 p.m. in the night, Fulchan informed about the incident of our phone. We immediately rushed to the house of the Fulchan and saw my brother in a senseless condition. Later, primary treatment was done hurriedly, and today, 15/8/23 at about 8 a.m. in the morning, injury is taken to Dhubri Medical College, Patti. That's the case. Now you will also kindly see this page 14, page 14. Page 1 for domestic violence case filed by that petition number 1. Shantimanu. That is filed on 29/11/22, my lord, last year. Your lordship, what is the date also, my lord? 29/11/22. In response, the notice was issued then, they also appeared. And thereafter, my lord, this case was lost. You'll kindly see the date, my lord. Present FIR is dated 16. You'll also kindly see page 11. Page 11. Page 11, serial number 3, date of occurrence 14/8 at 9 p.m. Information 17/8/23. So this FIR was on 17/3, dated 16, but it was registered on 17/8/23. And in this case, your lordship will find the petitioners accused are number 1. Your lordship will find accused number 1 is Shantimanu, the second wife of that injured person. Second wife of injured person. Number 2 to 5 are all the paternal uncles. Number 6 are his mother. And all these ladies got already interim bail. They already appeared. 3 ladies are. And petition number 3 in the meantime arrested. Your lordship.
Who has been arrested?
Yes. Petition number 3 is Sagar Ali. After filing of this case, he has been arrested. He is arrested on 6/11/23. 6/11/23. The rest pile of 5 persons remain. Out of 5, number 1, and then number 5 and 6 already intact. Ladies, all these ladies. And the rest one is Kadir Ali, paternal uncle. 4 is also paternal uncle. 2 and 4. They are not in interim. Now only because her father is bedridden, And this uncles, paternal uncles are taking care of her, my lord. Her legal battle, domestic violence case, they are taking care of those cases. And because of that, in order to get rid of that cases, my lord, this case was lost. And in fact, nothing, my lord, you have stated, no injury as such was my lord caused to them. I have stated categorically, my lord, that paragraph 4, my lord. Paragraph 4 is my contention, my stand in the bail petition. Paragraph 4, page 4.
What was the injury?
Lordship, I have gone through the case diary. And Lordship, petitioner number 1, 5, and 6, that is already under interim protection from this Honorable High Court. And so far as petitioner number 3 is concerned, Lordship, the case diary reveals he has been arrested, Lordship. And 2 and 4, Lordship. And now 2 and 4, Lordship, before Lordship, and the case is registered under section 326. And in the meantime, we have already received the medical report, Lordship. And medical report says simple cut injury caused by lightweight sharp object.
Simple by cuts. Case 26 is not coming. He is just waiting. Purely family matters, well, custodial integration, my lord. And we have stated a self-entreated, my lord. We are getting our statement as that. Wanted to get rid of that, my lord, case.
But there are places where simple cut injuries may be,
No, maybe simple cut injury, maybe by
maybe may cause result, may,
nothing happened thereafter, my lord. Thereafter, nothing happened. And we have stated categorically, my lord, he is okay leading a normal life without any problem. Your lordship is our submission, my lord. And 18/9/20, he appeared before the court.
what is there material against the 4 and 5?
Lordship,
Who?
Or 2 and 5.
2 and
2 and
4,
4.
2 and 4 is before Lordship right now. 1, 5, and 6 has already granted interim bail, Lordship. And 2 and 4, Lordship, they were present at the time of occurrence.
But who cut?
Who cut, that is not specified.
That is not.
That is not specified. And on the top of that, Lordship, there is a civil suit. There is a DV case that is filed by the
wife
of Lordship informant. That is petition number 1, Lordship, against the victim, Lordship, that is Muhammad Ali.
What is your submission?
Lordship, if already 1, 5, and 6, they are on the interim, they have appeared before the IO, and one person is already arrested, Lordship. And it's medical report shows simple injury, so let them appear, Lordship.
Third, Mr. H.R.H. Chaudhary, learned counsel for the learned senior counsel, assisted by Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by 6 numbers of petitioners who were apprehending their arrest in connection with Fakirganj PS case number 139/2023 under section 341/326/307/34 of the Indian Penal Code. The gist of accusation against the present petitioners is that on on 16/8/2023, one Saiz Uddin lodged an FIR before the officer in charge of Bondihana police station, inter alia, alleging that on 14/8/2023 at about 7 p.m. the brother of the first informant, namely Muhammad Ali, was called to the house of his second wife by making a call over telephone, and when he was going to the said house, 4 to 5 numbers of persons restrained him and assaulted him in his private parts, causing injury on his private part. Thereafter, he was hurriedly taken to the hospital for providing medical treatment. Learned senior counsel for the petitioners has submitted that prior to lodging of the FIR against the present petitioners, the petitioner number 1, namely Shanti Bhanu, had instituted a case under domestic prevention of a domestic violence case before the court of London Chief Judicial Magistrate Dhubri against the alleged victim and his family members. And learned senior counsel has submitted that the present case is a counterblast against the case filed by the petitioner number 1, Shanti Bhanu. It further submitted by learned senior counsel on behalf for the petitioner that in the meanwhile, the petitioner number 3, namely Sagar Ali, has already been arrested, and hence the anticipatory bail application in respect of the said petitioner has become infected. It is also submitted that the petitioner number 1, namely Shanti Bhanu, and petitioner number 5, Asma Khatun, and petitioner number 6, Jahirun Bibi, were already granted bail, interim bail by this court by order dated 19/10/2023, and in pursuant to the directions of this court, the said the above named petitioners have appeared before the investigating officer and has cooperated in investigation. On the other hand, learned additional public prosecutor has produced the case diary of Fakirganj PS case number 139/23 and has submitted that the petitioner number 1, 5,
And
6 have already been have appeared before the investigating officer, and their statement have already been recorded under section 161 of the Code of Procedure. It is also submitted by learned counsel for the learned additional public prosecutor that the medical report of the injured victim shows that the injury sustained by the victim is a superficial cut injury and is of simple nature. So considering the fact that the nature that there are pending litigation between both the sides, and also considering the fact that the injury sustained by the victim in this case is superficial cut injury of simple nature, the custodial interrogation of present petitioners does not appear to be necessary for fair completion of the investigation in Fakirganj PS case number 3139/2023. Therefore, in view of above, the interim anticipatory bail granted to petitioner number
1, 5, and 6.
1,
5, and 6.
1, 5, and 6, namely Shanti Bhanu, Asma Khatun, and Jahiran Bibi respectively, is hereby made absolute. Stop. Further, the petitioner number 2, Kader Ali, and petitioner number 4, Saban Ali, are hereby directed to appear before the investigating officer of Fakirganj PS case number 139/2023 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Fakirganj PS case number 139/23, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that they shall cooperate in the investigation. With above observation, this bail application is thereby disposed of. Send back the case.
May I present that? In this matter, there was
Case diary is here.
petitioner was allowed to go on interim, and when he appeared before the IO, he was arrested in another case of similar nature, Lordship. FIR at page 8, Lordship.
Now you are behind the bar.
Bar, Lordship, but on interim in this case, Lordship.
This interim we may, have you appeared?
He had, yes, his statement was recorded. I'll just check up once again, but other evidence are not against him. He is the owner of that, the building, it seems, right? Where the pharmacy is operating. And the main allegations were against one doctor who had impersonated himself as a doctor, and he's not a doctor.
Okay.
Yes, and he is doing certain illegal activities like doing abortions and giving birth to babies. But as far as his statement, I don't think so, no? No, I mean, it is Moinul Haq is examined.
Yeah, it is Moinul Haq.
He's examined by the police. Huh?
Yeah.
Huh? He appeared. Moinul Haq. Zarina Khatun, Moinul Haq statement.
When have you appeared?
Second.
Yes. He has given his statement.
Okay, heard Mr.
I have in fact read it.
M.K. Hussain, learned counsel for the petitioner. Also heard Miss S.
S. Jahan.
Sorry.
It happens.
Heard Miss S. Jahan, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner was granted interim anticipatory bail by order dated 31/10/2023, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer. On the other hand, Mrs. Jahan, learned additional public prosecutor, has produced the case diary of Morigao PS case number 382/2023 and has submitted that the petitioner has appeared before the investigating officer, and his statement under section 161 CRPC has also been recorded. Considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 31/10/2023 is hereby made absolute. Send back the case.
All right.
48 to tomorrow.
May I please, Your Lordship? Anticipatory bail application, my lord, and there are three petitioners, my lord, before your lordship. FIR is the page number 14, my lord. Allegation is that by punching the victim, my lord, his tooth was open, my lord. And although there is another allegations, my lord, and medical report is concerned, and admittedly, my lord, there is a scuffle between the petitioner number 1 and the victim, my lord. And so far, the injury concern medical report is necessary, but the medical report is there.
But here, we have received one medical report, my lord, preliminary, my lord. Hereafter, he was referred to the, my lord, Mongol Civil Hospital. Hereafter, as per FIR, my lord, it has been further referred to GMC for better treatment, my lord. Therefore,
In this regard, my submission is that, my lord.
For the informant here.
In this regard, my lord, my submission is that,
Injury is grievous in
or not, that is medical is necessary, but so far the objection filed by my learned friend, my lord, for the informant, and the FIR is concerned, shows that, my lord, by a punch, the foot, it was broken. So punch may be given by one person, my lord, not by three, my lord. So here admittedly, there is a quarrel between the petitioner number one and the victims. And other two petitioner are the brother of the petitioner number one. And during the scuffle, my lord, they are present there. Therefore, they are incorporated in the FIR, my lord. So, my lord, as this is my lord, medical report may be called for an interim protection for the petitioner 2 and 3 may be given, my lord. That is my humble prayer, my lord, at this stage, my lord.
Lordship, in para 6, your lordship, page number 7, your lordship, he himself admitted that three
that is I am submitting, my
petitioners,
lord.
lordship, jointly present there and all are attacked.
My lord,
victim, your lordship.
Court petitioner, 6.
Two are brothers, your lordship, of the petition
My
number 1.
submission is there, my lord. Punch may
And
be
all
given by
are
one
present at the
person.
incident, your
I am submitting that, my lord. At that time, other two brothers are there and they are trying to clamp down the situation. As they are brothers, that's what they are not
medical report
incorporated.
kindly call
That
for
is
your
statement in
lordship,
the
short date
paragraph
may be given,
6,
your
my
lordship.
lord. So at this is it is the after third that this was come up today, my lord. In earlier two occasions, it was left over, my lord. So this is only for the petition number 2 and 3. I am not playing for any interim protection for the petitioner number 1. That may be your lordship may decide after perusing the medical report, my lord.
my lord, here we have received the case diary along with the statement of the injured person also, my lord.
it is not there.
Here, my lord. Injured report, injured person statement is here, my lord. Lordship may peruse, my lord.
Who has
My lord.
assaulted him?
My lord. Eh. Oh, yeah, it was in my- बात नहीं मोहल्ले तो नहीं मैंने बात मोहल्ले का बात नहीं भेजे थे
Who assaulted? According to you, who assaulted?
As per my statement, my lord, my submission is that there is a scuffle between the petitioner number
But
1 and the
who was the person who assaulted?
as the petitioner number 1. It was to save himself, punch him, my lord. But it was what is the injury that is required, my lord? And other two are brother and my lord, brother and cousin brother, my lord. They are when they are along with them, my lord, suddenly this incident happened, my lord. And issue is there is a long enmity regarding my lord construction work, my lord.
I'm unable to read the work.
my lord, that
which
is, I have,
you have underlined.
my lord, I have,
The handwriting is not
my lord.
Gitanjali Dioksan.
FIR also disclosed, my lord, there is a enmity
That
between.
red underlined word.
My lord.
What is the name?
May I read, my lord? Read me.
Only name.
My lord.
The word which you have underlined with red.
My lord. 6:30 বজাত মই আকাশ আলীৰ কাপোৰৰ
But
দোকান
Akash is
my lord, owner of the my lord where it was incident took place, my lord. In the shop of the Akash Ali, my lord.
okay.
The incident took place, my lord. আকাশ আলীৰ কাপোৰৰ দোকানৰ বাকী টকা দিবলৈ যোৱাত নজৰুল ইছলাম, মুজিবুৰ ৰহমান, হাছেম আলী দোকানখনলৈ যায় আৰু মোৰ লগত প্ৰথমতে পুৰণা কাজিয়াৰ বিষয়ে তৰ্কাতৰ্কি কৰি মোক অশ্লীল কথা প্ৰয়োগ কৰি গালি গালাজ পাৰে।
মই উত্তৰ দিয়াৰ লগে লগে নজৰুল ইছলামে মোৰ মুখত এটা প্ৰচণ্ড জোৰে ঘোঁচা মাৰি দিয়াত মই পৰি যাওঁ।
Petitioner number two,
My lord.
it is not one.
মই উঠিবলৈ চেষ্টা কৰাত হাছে মালিয়ে মোক সাবটি ধৰে। সাবটি ধৰে আৰু দোকানৰ ভিতৰতে নজৰুল আৰু মফিজুৰে মোক ওপৰ জুপৰি মোক খুচিয়াই ডিঙিত চেপা মাৰি ধৰি মোক হত্যা কৰিবলৈ চেষ্টা কৰে। It is the statement of the injured man.
All are present here. And
The
SSP is present.
the injury report would be read.
My lord, my lord.
Can you given a short date here, please?
Heard
A short
Mr.
date may be given, my lord.
Heard Mr.
M.A.
M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr.
AAR Karim.
A.A.R. Karim, learned counsel for the petitioner, learned counsel for the informant. Learned additional public prosecutor submits that though the case diary has been received, however,
Final medical report
final
was received.
injury
One
report
preliminary injury report received, but it was thereafter he was referred to the my lord Mongoloi and thereafter GMC.
from where you have
My lord GMC, my lord.
the injury report from GMCH has not been received,
Right.
which may be necessary for consideration of the instant bail application. And hence prays for some more time to produce the said injury report.
My
The
lord,
prayer is allowed.
my lord.
Let this case be listed again on
8th, my lord, 8th of December.
8th of December for injury.
Maybe, my lord, earlier that is possible.
No, my lord, if they have not collected, they will have to collect this, my lord. From the
Let it
GMC.
be.
My lord.
8th of December, my lord. Obliged.
Obliged.
This is 438 application.
అయ్యో పోలే నా ఎక్కువ
Yes, there was called for a minute.
Case diary is here. The allegation is that the petitioner had done certain bad acts with the victim, and so victim committed suicide. That is the allegation. I've gone through the CD. Of course, the father, mother, sister, they have all stated against the accused person that he had done this, that in the classroom, certain allegations were made. But other students, what I find, they have not stated anything against the teacher, the petitioner. They have said that no, he had never misbehaved with any other students. This is what I find in the case diary. As far as mother, father, what the victim had stated is there. And it's a case of suicide. Non-continuous ligature mark high up in the thyroid. So this is a suicide, case of suicide.
And what is the allegation that
That he had done certain things with the girl in the classroom. He said her to open